Yes. I will pardon my lord. Land action up to 42 by 2017. It was.
You are giving a memo.
Yes, I am giving a memo.
Yes, you filed it.
It was previous judicial
So
order.
that is not binding on me. You must understand.
Yes.
In judicial side, that's not binding. Much
Yes.
less in administrative
No, I
side
am
when
filing,
listing is a
filing.
separate mechanism.
Memo in the thing.
So you file it. Whenever you are facing any difficulty, please mention the urgency. The instruction is all matters will be listed. And yesterday, as I have marked, since I have started yesterday this roster, 2 fresh admissions. Everything else is pending. Even interventions are being argued as if the final argument after 9 years, 10 years.
It is also very.
So the call is to be taken by the bar, not by the court.
Yes.
Yes, sir.
I mean, pardon to mention your lordship. So in this case, the case is
Memo
pending.
nahi janu sab.
Case is
Kindly
pending.
give the memo to Mr. Patnaik.
Case
Sorry,
is pending since 19.
Sir, there is
2019.
no. I will not point out in any matter that this is to be taken up ahead of others. My predicament is that I cannot choose you. You saw Mr. Jena. If you want listing of your matter, you have to file a memo. Give it. Yes.
Item number 35 permitted to withdraw.
Give the memo, sir.
Yes, I'm giving. The client is also there.
Sorry,
The party is the petition.
Mr. Divedi. Dismissed as withdrawn.
Yes, your Honor.
Stay.
There is no stay. Nothing.
Anyway, entry matter thibo vacant
It's
kar-
because the first time after notice the matter is listed. First time.
No, you are for the petitioner.
Petition.
So it is undelivered with the opposite party. Yes, next.
Pardon to mention, my lord, is a regular.
Give your memo. Give your memo. No priority, sir. No priority.
My lord, I may pardon, my lord. My lord, item 18,
Yes,
my
please,
lord.
next.
Item number 25. So I prefer na adjournment.
25, which year, sir?
24, lordship.
Which year? Which year?
24.
2024.
24.
Your name, sir?
Kamalakant City.
Acha, you are there. When do you want, sir?
I am adjournment, lordship. 2 weeks.
Yes, when do you want? Kebe chahuchanti?
2 weeks. Stay.
Yes. 2 weeks after the date kar diyantu. 12/5. 12/5, Mr. City.
Yes, lordship.
Yes, next, please.
My lord, sir,
I beg to.
31.
Arjun 2 weeks.
Your name, madam?
Yes, Sahoo.
S. Sahoo for the petitioner.
Yes, my lord. Entry order.
You have all these matters you have informed your other side. Ran away. He's KK City, but not Ran away City. Anyway. That is a fresh matter. Acha, this matter, if I am marking it, but since you are mentioning out of turn for adjournment, the other side must be present. It's after notice matter. Please appreciate that also. When do you want?
Entry order to continue. I may reject.
That will not be continued without passing any order. I am not continuing any interim order. If you want adjournment, it has to be both the learned councils, because it's an order against the other side. That is not to be granted for asking. So when do you want? How much time you want?
2 weeks.
Inform the other side. If the other side doesn't agree, it may be listed tomorrow. Must appreciate that. Yes.
Pardon to mention, madam. Item 3, madam.
Item 3 sanction padijibo. You want to leave the courtroom. So you request. Why to take out of turn item 3, item 2? You to reach soon.
Item 29, Arjun.
You are for?
Opposite party 1 and 4.
You have informed the petitioner. So, you are Miss Sonali Parda. You have to OP 1 and 5.
1 and 4.
Whenever you are mentioning out of turn, after notice matter, please the side. If they agree, it will be urgent, or else it will not be urgent. So, how much time you are requiring?
1 week.
You have marked whatever you have mentioned. I'm not granting adjournment. You are requesting adjournment.
My lord.
I am obliged that you agreed that in absence of other side, I will not grant adjournment. I am obliged.
My lord.
Yes, next.
Item 21, may I mention, your lordship? Item 21, your
Yes,
lordship.
everyone is mentioning. Why not you?
Lordship, I'm being
Yes.
led by Mr. Pale, the senior advocate. Your Lordship, I had requested Mr. P.K. Nanda, who is the counsel for the PPD,
You are
Mr.
led by.
P.K. Nanda. I'm
You are
being
led
led by Mr. Palit, Your Lordship. Mr. Palit, the senior advocate. Your Lordship, I only pray for next week, Your Lordship. Here the
No,
pleadings
yes,
are
yes. 1 week after, if they do not appear or they agree, but if they do not agree or say, because then even when the petitioners are appearing in, matter is urgent also. Please appreciate that difficulty. So since they are
Lordship.
not present, I am marking each and every mention. That I can.
Lordship.
1 week after. You have information. Pick on the.
Yes, Your Lordship.
Yes,
He didn't
yes,
pick up
yes.
the phone, but I have messaged
That also
you.
I have marked. Yes.
Lordship.
Yes. Yes, next. Any mention? Yes.
Item 1, on behalf of Mr. B.K. Kun, I am permitted to place this fact of the case, Your Lordship. Here is the
You are
case.
Mr. Sahoo.
No, S.J. Mahanti, Lordship. Sarathiyati Mahanti, Lordship. I have power not, in this brief, I have no power, but on requested by Mr. Kun, I have placed this fact, Your Lordship. Lordship, this is an application for transfer on the behest of the wife from the review case number 11 of 2021 from Sukinda.
You are ready for because it's a leftover matter. You must. It will be. This is for. I mean, after notice. Yes. What do you say?
My lord, I say at least maybe taken up in Jajpur, my lord. Transferred to Jajpur, my lord. Middle place, my lord.
You agree?
No, Your Lordship. May I clarify that?
Don't say everything. No, it is not my proposal.
No,
So have you taken instruction that that it cannot be at Jajpur?
Yes, I am.
Mr. Mahanti,
Your Lordship.
instead of making gestures to the court, please answer the question.
Yes, I am definitely.
So how do you know that he will propose Jajpur?
Yesterday I have talked with him.
So that you have to tell me, or I will know that. Because I know everything.
May I clarify why Jajpur not? I am not interested, Lordship. Kindly clarify, Lordship.
Sir, I am not seeking any clarification.
Lordship.
You must understand this is not a proposition of the court. This is proposition by the.
Yes.
Yes, you want transfer from where to where?
Sukinda to Chandikhol, Your Lordship.
Sukinda to Chandikhol.
Yes.
Why do you say Jajpur?
Middle place, my lord.
Jajpur, why do you say middle place, Koda?
My lord, petitioners.
Chandikhol is the middle place.
Very strong.
Chandikhol is the.
It is harmful for the petitioner to travel to Chandikhol, my lord. They are threatening, my lord.
Have you lost any complaint?
No, my lord.
You have to. You see, oral consultation, conversation between the parties. How do you drag the court into it? He is saying the heaven will fall. He is saying
There, my lord.
heaven will fall. You are saying you will be bitten. How the court adjudicate?
Maybe transfer to Jajpur.
You see, Sukinda, Jajpur and this Chandikhol, actually, they are not far off places.
No other court in.
You are aware of the geography?
My lord.
Yes. So, Mahanti, you are also aware?
Lordship.
You belong to which place?
Lordship, District of Bhadrak and Tehri, Lordship, under
So then you must
But I have
understand
idea about Chandikhol, Jajpur Road, and
so Chandikhol, in fact, is the middle place. Jajpur is not the middle place.
Right, Lordship.
So you want to add Chandikhol?
Yes, Lordship.
So you file an affidavit that you will be apprehending exact nature. If it is vague, his prayer will be allowed. So, but
before
thing is that
before filing my affidavit, Lordship, I have to accept the case for Lordship. Why I am checking for Chandikhol, Lordship. Kindly visualize, Lordship. The present husband,
Mr. You cannot compel the court to hear now and decide. So why to waste time?
Lordship,
your very good reasons of heaven falling because the matter is taken up.
Yes,
if you want to show that because it is in YouTube, fine. If somebody is watching,
no, Lordship.
Then do some better cases.
Yes, sir.
You see, you cannot justify the transfer the way you are. What is the ground? The best ground you have for transfer?
Yeah, because the present opposite party husband belongs to district of near to Lordship. The 3 kilometers.
Look at the Hindu Marriage Act. You are arguing against it. Hindu Marriage Act specifically says that where the person last decided. So a court cannot overrule Hindu Marriage Act. If I record, there will be problem for you. So the less you submit these vague arguments,
Then let
That
him allow
somebody
to file
says,
affidavit.
you see that, see his argument also.
That let him allow to file affidavit, Your Lordship.
No, it's not a question of affidavit. Suppose he says, you are saying where you will be beaten?
Chandikhol, ma'am.
Chandikhol will be beaten. Where you are safe?
In Sukinda, ma'am. Near Dharmasala, ma'am. Where he is residing.
There is no court at Dharmashala. That is yet to happen in Family Court Act or Hindu Marriage Act. That wherever they decide and they feel safe, there the court will start sitting. And Cuttack, everyone is safe. Both of you are feeling safe at Cuttack.
Safe question. I am always safe. I am not disputing safe.
If you are always safe, then
Yes.
then you are for the husband or the wife.
Husband, madam.
So if you are always everywhere safe,
Yes.
then he is so apprehensive to be beaten at Chandikhol.
There is never question. That part, Your Lordship, is absolutely incorrect, Your Lordship.
No.
Husband, wife, you could is it practicable, Your Lordship?
You see, please don't be so vociferous.
Lordship.
Don't identify with the wife or the husband. So how do you know that he will not be beaten? So you do one thing.
Lordship.
You do one thing.
Lordship.
That at Chandikhol, you want at Chandikhol.
Lordship.
So you file that affidavit that he will be absolute safe. One line affidavit to file.
May
It is submitted by the learned counsel for the petitioner. Then it appearance dekhiବାକୁ ପଡିବ. Mr. Sahasrajyoti Mahanti on behalf of BK Kund. This legal strategy of dragging this litigation by TCRL or TRPC is always a bad strategy. Apart from lawyers is one thing. Because here nothing is decided. Nothing is adjudicated. The litigation is dragged.
Lordship.
The Mr. Sahasrajyoti Mahanti on behalf of BK Kund, Vikas Kumar Kund for the petitioner. Mr. You have power here.
Yes, my lord.
R.R. Misra.
K.N. Panda, my lord.
Mr. K.N. Panda for the opposite party. The petition has been filed by the wife in the lower court. What you are? Apna kaun lower court re?
Lower court, I am the petitioner, Lordship, filed the DV miscase under section 12 of the DV.
Filed by the wife in the DV miscase. Who is the petitioner? Who is the petitioner in the DV miscase? Filed before?
Before the JMFC in
JMFC Sukinda. Gramonayala come JMFC Sukinda, DV number 11 of 2021. The wife seeks transfer of the matter to
Gramonayala come JMFC Sukinda to.
You see, you have filed in Sukinda, you yourself you are opting for Chandikhol.
Lordship.
Change of mind.
No, Your Lordship. At that point of time, after husband was there a discord between the husband and wife, I am removed by the husband and staying with my parents at Sukinda. After demise of my late father, my brothers are not taking care of me. Therefore, I shifted to Chandikhol and staying in rented house.
From Sukinda to Chandikhol. Both being in the district of Jajpur. To justify the change of mind of choosing the place of prosecution by the wife who has initiated the petition, initiated the proceeding, it is submitted that the petitioner wife was staying with or being estranged. The petitioner being estranged from the husband was staying with her brothers at Sukinda. She filed the petition at Sukinda.
May interpret your Lordship in here.
If you want to dictate the order, you bring your own steno. If you want to dictate the order, then please tell me that I will dictate the order.
No,
because I can't continue like this. In fact, I have lost track. Or else you please have your entire submission. Leave this habit of interrupting the judge.
At the time of filing, father was alive. That part I
please. I have not said anything what you have not said. If you want to say so many people are alive, you can. That's not relevant. You see, it's an open court. If I am changing anything, then you can say that I have not changed anything. ଆପଣ କହିଲେ ମୁଁ ଯାଇକି ରହୁଥିଲି ଭାଇ ବାପା ମୋ ଭାଇଙ୍କ ପାଖରେ, ବର୍ତ୍ତମାନ ଭାଇ ମତେ ଭଲ ପାଉନାହାନ୍ତି। ଟିକେ ଆପଣ you should be patient to hear the
Sir.
completion of the
Sorry, Your
sentence also.
Sir.
କଣ ଲେଖିଲେ? ସେଣ୍ଟେନ୍ସ ଟା ମନେ ରହିଲାନି। Retrench, no. Being estranged. See what is happening. He has lost track. You have converted into a... कौन लिखले? Estranged from husband, was staying with her parents and brothers. ଆପଣ ବର୍ତ୍ତମାନ କିଏ ଭଲ ପାଇଲେ, କିଏ ଚାଲିଗଲେ ଆପଣଙ୍କର?
ମୋ ବାପା ମରିଗଲା ପରେ ମୋର
ବାପା ମା ଜାଣିନାହାନ୍ତି।
ଆଗରୁ ମା ମରି ଯାଇଥିଲେ, ମୋ ବାପା
ଠିକ
ଥିଲେ।
ଅଛି, ରୁହନ୍ତୁ।
ଆଜ୍ଞା।
କଣ ଲେଖ? Being estranged from husband ଛାଡ଼ିଦେଲେ। और estranged with हବ। ପରେ correction हବ। Husband was staying with her father and brothers. तापर कौन लिखी? At Sukinda, she decided to file the petition at Sukinda. It is further stated that after death of her father, आंको नारे domestic violence कले ना नहीं, भाई मानो को नारे?
No.
ही परिवो?
Lord sir, I am not.
ही परिवो because they are now torturing you.
What's that?
सेटा भी करूँ। कौन लिखले? और ये जाजपुर आपण चंडीगढ़ शिफ्ट कला पर सेटा करी परिवे because you will be beaten there again. कौन लिखले? Father, she is ill-treated by her brothers and now doesn't want to prosecute the matter at Sukinda. She has shifted to Chandikhol. Chandikhol le कोट रहो चुके
In a rented house, Lord sir.
Shifted to Chandikhol, staying in a rented house, and once shifting of the transfer of the petition, चेंज न करके लिखंतु थोड़ा गैप रह जो मुक कर दे लेकिन चेंज कर देले वो जान परिबेन और लिखले सेंटेंस से लास्ट टू कंक्लूड कले Chandikhol staying in a rented house and seeks transfer of the petition to Chandikhol. आपण जाउछन जाजपुर रोड
Jajpur.
The learned counsel appearing on behalf of the opposite party submits that opposite party husband before this court as well as in the opposite party in the domestic violence case pending in Sukinda submits that he apprehends ill treatment and manhandling by wife oblique her relations oblique her agents at Chandikhol, and the matter may be transferred from Sukinda to Jajpur road sida
Jajpur.
to Jajpur. Para in response, the learned counsel for the petitioner, Mr. Mohanty, submits that there is absolutely no apprehension. There cannot be any apprehension of any ill treatment, threatening, manhandling to the husband at Chandikhol. Since the wife has chosen the place of initiating the proceeding and again has decided to transfer to apply for transfer of the proceeding, she shall file affidavit stating that there would be no apprehension to the husband as expressed at Chandikhol. List on 1 week time देउन 1-5-20-25 you file that one line affidavit, it will be disposed of. You get your whatever you want. So I will not allow to also Jajpur road till you make up your mind to shift at some place, because there are some places again after 1 month She will file that I will want to get it to Sukinda because I have shifted to Sukinda. It happened in one case.
Lordship, here is a case, good grounds for transfer. I have already stated in my
Correct.
paragraph.
But grounds of transfer merits because it's based on apprehension. So you file that one line affidavit and it will be
I have no
allowed.
apprehension
Your
in-
prayer will be allowed.
Yes, sir. I have definitely.
List on 1-5-20-25.
Interim to continue. Lordship.
Affidavit ଏଥିରେ ଆପଣଙ୍କ ପିଟିସନ ଟା ଷ୍ଟେ କରିଛନ୍ତି?
ମୁଁ ଏଠି ଚଣ୍ଡିଖୋଲରେ ରହୁଛି କି ସୁକିନ୍ଦା ଯିବା ଆସିବା କମ୍ୟୁନିକେସନ ଡିଫିକଲ୍ଟ ହେଲା।
The wife
55
has
kilometers.
obtained stay of the further proceeding in DV number 11 of 2021 where she herself is the petitioner. The interim order by interim order dated
26/11/2024 your Lordship.
26/11/2024. Shall continue till 1-5-2025. नहीं हमें कितने डेट दिले? एक 5 2-5 कर दे। 1-5 कर दे। Next Monday. 5-5-2025. Yes.
Right. Obligation.
You serve a copy of that affidavit.
Yes,
Yes.
after serving.
Item 2.
Yes.
Please, Your Lordship.
Yes.
The petitioners seeks to transfer of CP number 727/2022, which is pending before the Judge Family Court Cutter to the Civil Judge Senior Division at Thagad.
Yes.
On the ground that the distance 50 kilometers away from Athagad, and the petitioner is
Who has
residing.
initiated the proceeding?
Milord,
Who has initiated the proceeding?
opposite party has initiated the proceeding, Milord. CP number 727/2022.
This employee, he's a employee of the High Court of Orissa.
Yes, Milord.
I am for the opposite party, your husband, Your Lordship. Earlier,
Has he told you that he worked with me?
Your Lordships,
Has he told you that he worked with me? He was working in my residence.
Yes, he is residing in here.
Not related to me.
No.
Has he informed you that he has worked in my residence?
I not inform Your Lordship.
On which one? Worked for some time at my residence. Not my residence, at the residence of MS Sahoo J. The matter may be listed before a bench where MS Sahoo J is not a member. After obtaining kind orders from the Honorable the Chief Justice in the administrative side.
Milord, interim order was.
Now I will tell you something. Why I have transferred. Yes,
May I please, Lordship?
Mr. D. Mahapatra.
My Lord.
You are Mr. Mahapatra.
No. TK, sir. Telecommerce. The opposite.
Item 3.
Petitioner.
Mrs. A. Das for the petitioner, Mr. D. Mahapatra. आपन नाडा अशोक कुमार बेहरा
नहीं नहीं अशोक कुमार नाम सिंह
आपन नाडा कोन
डीके साहू दिलीप कुमार सिंह
पावर नहीं पावर फाइल करना है you are on behalf of DK Sahu on behalf of
एके बेरा मतलब
again
एके बेरा अशोक कुमार
ठीक है माइक्रोफोन को कौन है I don't understand
एके बेरा अशोक कुमार बेरा
Mr. A.K. Behra for the respondent opposite party yes Mrs. Das
मतलब after vacation मतलब
after vacation there is interim order.
May I be pardoned, my lord?
The Learned Counsel for the opposite party prays for the matter to be listed after ensuing summer vacation.
My lord. I'm on Vichy mode, my lord. It is item
Learned,
4, my lord.
Counsel Mrs. Das appears on behalf of the petitioner. As prayed for list on, you want a date? After vacation date कर दियो 18/6/2025 list interim order passed interim order dated 23/9/2024 shall continue till the next date. Yes, next please.
Item 4.
Next date of listing कर दियो आपका list over जल्दी पर लिख दियो तो liberty to mention.
Item
Liberty to mention for listing wherever stays there, write that liberty to mention for listing before the assigned bench. Yes, please.
Item 4, I'm on VC mode, my lord. Item 4, I'm for the petitioner, my lord. And this petition was filed to under section 24 of CP to transfer the CP case number 51 of 24 transfer from Nabarangpur to
Yes, ask for
Ganjam.
the petitioner. Yes, what happened to the notice?
My lord, despite of several notice, none has appeared from sole opposite party, my lord. And notice was sufficient. The noting itself says that noting is sufficient.
You have served this notice through the court where the matter is pending.
My lord, the note. I have served notice, my lord, and filed requisite and duly served notice,
Have
my
you
lord.
served the notice through the court yet? Where the matter is pending.
That instruction I have to take, my lord, because
No,
the
no.
notings.
You are the counsel from whom you will take that instruction.
Actually, the thing is that Mr.
As a counsel,
Panda was
you will be
appearing
knowing
till
that.
date, my lord.
No, you will instruct others, not anyone will instruct you.
I'm sorry, my lord. But
Why should you be sorry again, sir? Then let us stop, adjourn the matter then. In a courtroom deliberation, you are saying something and I'm asking you something, you are saying sorry.
No, my lord.
Unless I know the facts, how do I adjudicate?
My lord, the fact.
Somebody may be having a understanding and
the
seeing
facts, my lord.
everything. I don't have that power. I have to understand what is happening. That is how the deliberation is most essential. And in procedural part, still more essential.
Yes, my lord. What instruction I have got, my lord, that notice was.
It is submitted by the Learned Counsel
served.
for the petitioner that despite notice being sufficient, no Learned Counsel has yet appeared on behalf of the sole opposite party. The office note put up by the registry, the date pad bhi podu nahi.
The notice.
At serial number 2. At serial number 2. Please stop. Please stop.
Yes.
I am dictating an order.
Yes, ma'am.
Office note put up by the registry at serial number 2 of the note sheet indicates देखिए लिखी हुए notice in the admission matter return to sender जहाँ से exactly produce करिए at serial number 3 3-4 the office note is to the effect that no Learned Counsel has entered appearance. So, through your learned colleague at the trial court, you will be able to serve notice.
My lord, I'll serve your lord's permit. I'll
The Lord
serve.
Counsel for the petitioner
Yes.
submits that CSL serve the copy of the order and as well as ଆଗ ଲେଖନ୍ତୁ service ପୂର୍ବରୁ ଲେଖି ଦିଅନ୍ତୁ in view of the specific provision କୋଉ provision ରେ ଅଛି that refusal will be sufficient.
Sorry, my lord. Sorry.
Which provision in the CPC provides that in case of refusal the notice shall be treated as sufficient?
That is ordered 5 rule.
So that should be your submission.
Yes.
One line.
Yes, my
Order
lord.
5.
Rule 4. I have forgotten, my lord.
One line. In the CPC, just fill up କରାଯିବ. It is submitted by the Learned Counsel for the petitioner that the notice be treated sufficient in view of refusal. Para. The notice to the opposite party is treated sufficient in view of his refusal to accept the same after issuance by this court. The Learned Counsel for the petitioner submits that CSL serve copy of the today's order along with earlier orders on the Learned Counsel appearing on behalf of the opposite party husband in the pending CP number 51 of 2024. Before the learned district learned family judge Nabarangpur. Upon filing of the requisites in that court for service of notice on the Learned Counsel appearing for the petitioner husband in CP 51 or in person, the same shall be served through the court. The service will be forwarded to the registry of this court to be placed for consideration on the next date. 2 weeks ପରେ ଗୋଟେ date ଦିଅନ୍ତୁ.
My lord, may premier interim order
List on-
pass earlier.
ଆଜ୍ଞା
Stay order shall passed earlier to be continued till next.
ଟିକେ ରୁହନ୍ତୁ list on 8/5/2025 registry to do the needful. Interim order dated 22/1/2025 shall continue till the next date.
Placement.
Yes, next. So, madam, you obtain copy, website copy, then file requisites there.
My
Basically, the Learned Counsel at Nabarangpur will download that and file the requisites in the court for service.
my lord, the question here asks under which provision of there is order 5 rule 21, my lord. I just forgotten.
Thank you.
My lord.
So this is the way this is. I mean, it's not important to remember the sections, but still, then it's a way to remember. We should read it and place it every day. Because if you know the concept, that solves the purpose.
Yes, my lord. I'm sorry and obliged.
Yes.
Item 5. May please your lordship. The present petitioner has challenged the order dated 29/9/2005 of the Civil Judge Senior Division Kamakya Nagar.
You are ready, Mr.
Yes.
So the last order.
No, yes, this is the first day of this taking up. But I will be trying to take up the leftover matters, even if after notice hearing matters, where LCR is available, the next date.
Yes, sir.
I tried to
No,
prepare.
that I'm telling you.
I tried my level best to prepare from the.
No, I
But
understand.
when LCR is
So
not there-
don't, I mean, it's not that usually the press matters are taken up in the morning. So that way the list will not be exhausted because there are so many after notice matters.
My lords. Lordship may allow me one opportunity. I'll collect the
Correct.
so that I will prepare.
Mr. Mahanti, you suggested date.
Your lordship.
Any day, my lords. I just need one day.
1
any
week,
day.
1 week ଗୋଟେ date କରିଦିଅନ୍ତୁ।
1 week.
12/5 will be shooting for Mr. Mahanti.
Yes, man.
Mr. M.K. Manoj Kumar Mahanti for the
Last year lordship kindly keep it on.
16. Sorry, I'm so sorry. 9 ତାରିଖ କହୁଛନ୍ତି।
9 ତାରିଖ, ହଁ 9 ତାରିଖ।
Mr.
My-
Prabhu,
Yes, my lords.
Last week it was hearing of the
Mr. M.K. Mahanti and counsel appellant, Mr. Prabhu Prasanna Behra, additional government advocate,
That's additional standing.
additional standing counsel for the opposite party state. The learned counsel for the appellant seeks urgency, pleads urgency for taking up of the matter. For taking up of the matter, since it is pending for a long time. The learned AC seeks 1 week further time to prepare the matter. To go through the brief and address this court on hearing. As prayed for list 5-25.
Item 6.
Your matter, Mr. Behra?
My lords. 6 may please. My
Again, hearing matter.
Yes, my lords.
Same order. Eta khali appellant kar debe. Apun kebe chahunchoni? When do you want?
This is actually a covered matter.
Sorry?
This is a covered matter. We have
You provide him the cover.
We have filed a memo.
Because the problem is that then he will run for cover after you provide the cover.
We have provided him. They can take instructions. Last
Well,
date
sir.
he was ordered to take instructions regarding the same.
That the issued letters, my lords. The lordship may give us any shortest possible date. I'll submit accordingly.
So Prabhu Prasanna Behra for the appellant. Kindly your name, please.
Lords, my name is Akansha Acharya on behalf of Mr. M.K. Mahapath.
Acha, Mr. Mr.
Right.
Akansh Acharya on behalf of M.K. Mahapatra for the respondent. The learned counsel for the respondent refers to that has been reflected in any order. Refers to order dated 10th of January 2025. Mr. Acharya, you should be, I mean, you should be prompt. At your age, you can't.
10th of January 2020.
Yes, 10th of January 2025 to submit that. This the appeal is covered by the disposed by the judgment passed in by the coordinate bench in LA number 57 of 2008 and LA number 56 of 2013. It is stated by the learned AC in response that he has forwarded the copies of the copy judgment. So there's a common judgment or two judgments, Mr.
Lords, two different judgments.
Copies of the judgments in the said laws, LAAS.
Yes.
Or the said appeals court seeking instruction
My lords.
and may be further accommodated by 1 week as prayed for. List on 12/5-20.
I'm obliged.
If I may pray one more thing, my
Please, please.
My lords, there is another matter connected to the same village.
Give a
Last
but please
53 of-
mention that it is connected with this IA 68 of 2006. Unless you write those things,
I'll file
you
a
have to
memo.
write specifically that IA law 68 of 2006 listed before court number 9 on so and so date. This is arises out of and connected to that, so that then they will list it.
Deeply.
Or you can bring that memo and give it to the court master.
I'll give it to the court master now.
Yes.
Deeply.
File a memo. Yes.
7.
Lordship, I'm appealing for Advocate Amit Patnaik.
Yesterday, you see, he sought for time actually. Miss, ଆପଣଙ୍କ ନାଁଟା?
Sashmita Kadanga.
You don't have power.
No.
Sasmita Panigrahi.
Khadanga.
I'm so sorry. Please use the microphone. I adjust it.
Sashmita Khadanga.
Miss Sasmita Khadanga on behalf of Amit for the appellant.
Yes, sure, Lordship.
Then you don't have power here.
So second matter.
First matter to take up करूँ. Sir,
For the respondent number 1 to 13.
Mr. Panigrahi.
Yes.
Mr. Kalpataru Panigrahi.
Yes.
For respondents 1 to 13.
Yes.
The learned counsel for the appellant, the learned arguing 20-25. 30. As prayed for.
On 30th, I have personal.
No. You suggested date. I am not insisting for that.
On one minor. One.
A के 5. Yes. Second matter.
Second matter, I am for the one
Same. Second matter लिखिबे. Appellant होचंती same.
Both the cases may be listed on the same day.
Yes, Sahoo. Same order करते हुए. Mr. Tripaঠি's power is there.
Yes, ma'am.
So yes, Sahoo, his senior counsel. Yes, next please.
Item 8.
Mr. Raut. None appears for the petitioner. Appellant none. Mr. Joshi, why you are respondent here?
I am for the respondent here.
Acquiring land also.
The appellant is acquired the land for the purpose of construction of Khurda Bolangir railway wing project.
Achha. You still require more land. You are not satisfied with the vast amount of land you are having now.
No, in fact, whatever money was paid, on being satisfied, referred the matter to referral court. Referral court was pleased to announce.
Regarding Mr. Joshi, I was saying, I was not saying about
Yes.
Kuber Mahakudda.
Oh, I did.
कौन लिख ले? So that is how I was thinking that how could a private person acquire land? See, sorry, your name, you are Mr. Ansuman Sethi. Mr. Ansuman Sethi, additional standing counsel for the appellant. Mr. S.K. Joshi. Yes, Mr. Sethi. Are you ready or you want to prepare for the, because it's a hearing matter?
No, delay has not yet condoned, my lord. The delay of 249 days.
Shall I condone?
No, you should see the.
No, shall I condone it now, Mr. Joshi?
No, it cannot be condoned, my lord.
74(1).
Section 74 of the 2013 Act.
60 days and another 60 days is a discussion.
120 days.
Thereafter cannot be condoned the court. But
But Supreme Court has said can be.
matter is pending
Before Supreme Court, my lord. Similar matter that is pending before the Supreme Court.
And that particular point, limit can be extended.
Yes. On the similar issue.
I'll give in that.
So it should be urgent, Mr. Joshi.
Yes, my lord.
The amount has been deposited.
Yes.
You have received the amount.
I have received under protest and sought for reference.
Correct. So I mean that part should be always there. The strategy should be that you receive it with protest and
Yes.
seek for reference.
Yes.
That is yes.
I have
I filed it. Number
This is item. No, this is for additional.
I2.
IA2 of 2022. Mr. AAC लिखिबे. AAC for the petitioner appellant. Mr. Joshi for
The respondent.
it is submitted by the learned counsel. এটা कर दियो तू Mr. जो AAC लिख लेनी की. हाँ, अंशुमन शेट्टी AAC along with Mr. Devraj Mahanti AGA. It is submitted by the learned counsel for the respondent. You are referring to Land Acquisition Act?
2013.
That is right to fair compensation and transparency, land acquisition, rehabilitation and resettlement act. The lordship say RR Act 2013.
No, these books have been arranged yesterday night at 9 p.m. So little bit more organized. You are referring to
4. Subclause 1.
Yeah.
Section 74 into bracket 1 provides the following. Which change kar lekho to 74(1) of the this Rehabilitation and Resettlement Act 2000. Yes, please. Next.
Item 9.
Mr. Sudeep Sodangi,
My lord.
for the petitioner. Why state, sir?
The case is that, my lord, one incident,
Mm-hmm.
one incident, two FIR. One is counter FIR, both FIRs were registered. Both.
Who is there? Who is the assigned learned government advocate, Mr. Sethi? Item 9, you are there? No. Please find out from your assignment who is the learned counsel so that I can mention his name. That is also part of your job. Because you have so many, but definitely they have to take some kind of break. Correctly? For the petitioner that there are two affairs, namely
165 and 166.
165. Detail ta kohibe na nai se dot ki jibbe.
2018, my lord.
2018. PS, co-PS.
PS, Jonk PS.
Jonk PS in the district of Sundargarh.
No, Jonk PS is Nuapada.
The district of Noapada. The other one being 166
of 18.
Of 2018.
My lord.
160 the FI number 166 of 2018. In the self-same PS.
My lord.
Also in the said PS. It is submitted that both the FIRs relate to case and counter case arising out of a single incident. However, incident that had occurred in 2018. The city case number 543 of 2018, corresponding to Jonk PS case number 166 of 2018, is pending before the learned SDJM Nuapada. The other case, number 542 of 2018, is before the Court of Sessions.
Additional session.
That is additional session judge. Nuapada.
My lord.
Nuapada. ଆପଣଙ୍କର ସେସନ୍ସ ଟ୍ରାଇବାଲ ଅଫେନ୍ସ ଆପଣ କରିଥିବେ?
ନାଇଁ ମୋ against ଅଛି sir.
Sessions tribal offense, if you commit, who will try the case?
It's Court of Sessions.
So what is wrong there? So you have to examine the law on this point. That whether the higher court, because if the other case is tried by the higher court, then the party loses the appeal.
My prayer before this court.
The prayer has been understood, sir. You don't have to repeat the prayer. After you say something, the court wants to deliberate with you. Don't go on repeating. Kindly listen.
Dita case re dita judgment alga alga heijo. That is why.
ଆପଣ ବୁଝି ପାରୁନାହାନ୍ତି sir, ଦିଟା judgment ଅଲଗା ଅଲଗା ହେଇଯିବ, ଆପଣ ଓଡ଼ିଆରେ କହିଲେ better ହବ କି? You have committed a crime, alleged crime, which is sessions tribal.
My lord.
You have lodged an FIR which is not sessions tribal, it is tribal by a magistrate.
My lord.
You want that the magistrate tribal offense should be tried by the sessions because.
Arising out of the.
So you examine the law, it is not that as simple as you are portraying. जो आपण साइड करचंती डिसीजन टा, whether you have to find out that whether suppose one is 10 years of imprisonment, sessions tribal.
My lord.
The other is 5 years of imprisonment, magistrate tribal. कौन लिख ले? Are you in anxiety that you are dismissed or what? You are not in fact, I am issuing notice but asking you something pertinent.
My lord.
Yes. नहीं लास्ट टा पढ़ंतु पूराटा पढ़ंतु नहीं असिस्टेंट ना एडिशनल
Additional.
कोड लेक्चर अपन सबुटी सेशंस कोड सेशन जज लेक्चर
वो prayer रहছে ଆଜ୍ଞା।
प्रेयर कथा पढ़िनी अपन एफिडेविट रे बा गवर्नमेंट रे कोड माने पिटिशन रे कोड लेक्चर
Petition para 1 ରେ ଲେଖା ହେଇଛି।
हां काइंडली फाइंड आउट
para 2 ରେ ଲେଖା ହେଇଛି ଆଜ୍ଞା। City case number
decision session judge coach national session judge in fact I dictated from there only decision session judge पाउचन ना पाउनांती हैं in page 2 last line kindly read
आगे आगे
learned district and session judge
my lord
माने if you travel through 6 pages कोन से assistant session judge हिजिबे ना कोन
नहीं सर वो prayer रे लिखी छी सर वो prayer
Oh.
it very clear
which is suddenly you are completely unmindful read para 2
my lord
you have not written my lord you are reading my lord
district and session judge it will mention
Yes, city case.
no para it is registered city case no
how do they obtain instruction if you make this kind of wrong statements in every page you describe it you do not know then
in that case 1 week time I will given I will
कौन लिख ले assistant session की district से जानना है before the sessions quote कर दियो before the sessions quote issue notice the learned Mr. Sanjeev Swami ji the learned AG upon advance copy served appears and waives notice we shall obtain instruction in the matter the learned counsel for the petitioner submits that at several places of the petition it has been stated that the case is pending before the session district and session judge additional district and session judge court with the he shall verify and obtain instruction the pendency of the both the cases at present at Nuapada. The learned AGA shall also obtain instruction through the concerned IAC regarding the courts where the cases are pending. Mr. Swami, he has cited a decision actually, Supreme Court decision.
Order has been passed saying that they're pending in the district and session judge Mapra.
He in prayer he says it is additional.
Let's check up.
So the only way to stay is that you stay all the cases pending at Nuapad. Yes, next. Date karantu date. After vacation? Na before vacation?
ଯୋଉଦିନ ହେଲେ କିଛି ଅସୁବିଧା ନାହିଁ
ସୁବୁନି ଟିକେ ମାଇକ୍ରୋଫୋନ ରେ କାଇଁ କହୁନାହାନ୍ତି କଣ ହେଲା
ଆଜ୍ଞା କିଛି ଅସୁବିଧା ନାହିଁ ଯୋଉଦିନ ହେଲେ
ନାଇଁ ଆପଣ ସେଥିପାଇଁ ତ ପଚାରୁଛି ଆପଣଙ୍କୁ ଆପଣଙ୍କ ଅସୁବିଧା ନାହିଁ ବୋଲି
ନାଇଁ after vacation
18/6/2025
Item 10.
And here the petitioner is the wife. Filed this transfer petition.
The Biplab PB Bahali for the petitioner. Yes, Mr. Bahali.
Petitioner is the wife filed this transfer petition.
Yes.
The divorce case filed by the husband before the family court Sonpur to the family court as the
Yes.
petitioner wife is residing in Jharsuguda in her parental house.
Take
And,
notice. High Court counsel for the petitioner. It is submitted that petitioner wife is the opposite party in the CP number 41 of 2024, pending before the Judge Family Court Sonpur, initiated by the husband under section 9 and 13 into bracket 1 of the Hindu Marriage Act 1955. It is submitted that due to the dissensions in the matrimonial relationship, the wife now stays at Jharsuguda. Mr. Bali?
Yes,
Jharsuguda. And is facing immense difficulty for prosecuting the matter at Sonpur. Issue notice along with this order. Stop Sopara. Requisites for issuance of notice. Issue notice along with this order, fixing a early returnable date. Full stop. Requisites for issuance of notice by SP registered post with AD be filed within
3 days.
Within 3 working days. List after SR. Yes.
Interim order I am for the stay of further proceeding. I filed
IA 100 of 2025. Hard-learned counsel for the petitioner who reiterates his submissions as noted above. Issue notice, fixing early returnable date. Requisites for issuance of notice by SP registered post with AD be filed within 3 working days. Then Sapara accept one set of process fee as well as postal requisites. As an interim measure, it is directed that the further proceeding in CP number 41 of 2024 shall remain stayed after vacation, Mr. Bali, or before?
Yes, after vacation.
Date karantu? 19/6. कौन लिख ले? Till 23/6/2025. List on 19/6/2025. Liberty to mention for listing before the assigned bench. से डेट ऊपर भी दे दो लिस्ट ऑन अपना पिटिशन रे भी डेट दे नांते ना पोस्टिंग डेट कर देबे लिस्ट ऑन एते लिस्ट आफ्टर एसआर कॉमा दे कर दियंतु ऑन एते केते गले 19/6 मिस्टर
Yes.
and interim order till 23/6.
Yes.
The next week Monday.
Yes.
Yes, next
11.
Mr. Swarjit Raut for the petitioner, Mr. Sanjeev Swai AGA for the state. Yes, Mr. Raut.
My lords, this honorable court on the last occasion has directed to
Instruction, Mr. Swai, have you received?
This matter, interim order is there in their favor. May I take 2 weeks time for filing count?
The learned counsel for the petitioner refers to earlier orders passed by the coordinate bench.
That is
Dated 11th February 2025 and the subsequent orders to submit that state was to provide instruction. State is to provide instructions. The learned AGA in response submits that he has sought for instructions and may be accommodated further by 2 weeks.
Yeah.
2 weeks means it goes after vacation, I think, or even before vacation.
so
देखो तो देख पर may be accommodated by 2 weeks. As prayed for list on paper you 13/5/2025. The interim order dated 11/2/2025 shall continue till the next date.
if my lords permit me, my lords, can I make
Please.
a submission?
Please.
My lords, item 30, same matter, my lords, same party, same cause of action.
38.
38. There is no interim order, my lords. Same party action.
38. Mr.
same-
Swai, who is your colleague?
30 I will intimate.
But the same order was there to seek for instruction. Means if both the matters can be tagged and heard, my lords. That was very clear.
Yes, not necessary.
30.
38, my lords.
38.
My lords.
38 who is appearing?
30 is the account. That is, I think Mr. Pradhan, Rajdeep has not come.
Okay. Mr. Pradhan.
Yes, ASC, Rajdeep Pradhan.
Let it someone come. Interim order nahi. Interim order patta rahibani. Interim order
Both the
likhi
matters
thoki
will
mar
be
diyantu.
heard
So that
together.
will indicate. Yes. Yes, next please.
Great for me.
So,
Yes.
I am for the respondent number 1.
Yes.
I am for the respondent number 1.
Yes.
Was already expired.
This will abate 12 who is appearing. You see, if you have not taken steps for setting setting aside abatement and substitution, you ask Mr. Mahanti, Mr. say appearance lekhantu Mr. Anshuman Sethi, AC, along with Mr. Devaraj Mahanti, AGA. You are Mr. Ratha.
No, I am Gyananandan Sahoo.
Mr. G. Sahoo. You are writing GR or G?
GR Sahoo.
G.R.Sahoo, SHU.
SH.
Why you are not filing?
SH.
This is your chamber brief.
It is
ସବୁଥିରେ କଣ ନାଁ ଲେଖା ହବ SHO for on behalf of the respondent along with Mr. Bansidhar Bag, senior counsel. On a instructing counsel, Mr. Sahoo submits that the respondent number 1 has since passed away and steps are yet to be taken by the appellants for his substitution and setting aside of amendment. The learned AGA 6 further accommodation. Learned AC 6 accommodation. How much time, Mr. Mahanti? Wait for list on. But diyon to date karan to ti jaldi.
4 weeks because I
Acha 4 weeks ka after vacation padela. So unless you initiated your clients will slip over it also. 14 कर दियो 14 5 20 25. Yes, next please.
13.
Same appearance, Mr. Sethi for the AC for the appellant. You are there for the respondent?
No, I am a respondent of 5AI.
5AI.
My lord.
Goodness. Mr. SS Mahapatra for 5AI. What about the others? Any idea, Mr. Mahapatra?
In this case,
Why this much of? Because that so many persons have passed away.
Your lordship.
5A then A, B, C, D, E, F, G, H, I.
They have been wrongly written that 5A because one, the Birendra Kumarjit was passed away. I am the son of, I am the daughter of Birendra
Submitted
Kumarjit.
by the learned counsel, Mr. Mahapatra for the respondents 5AI as mentioned in the counsel cost title that there is some discrepancy.
Your lordship.
In the amended cost title?
Yes, yes.
The learned AAC in response 6 accommodation to obtain specific instruction and amend the amended cost title if so advised. You have to amend again because I think because he is appearing from their side, he must be knowing who are the son, who is the grandson. What is the mix up? Grandson by son or son by grandson? Who has been mixed up?
This is daughter, my lord. Can you see?
Also there.
Yes, yes. Can you see?
So you obtain specific instruction, written instruction and substitute. Ask Mr. Swine, Mr. Mahanti. List on केते देले 14 ना 15 दे 14 5 20 25.
Obliged.
Unless you make them a proper partisan record, there will be very difficult in issuing notice also. Please appreciate that. Yes.
Obliged.
14. 14, Mr. S.A. Mahanti. S.A. Mahanti for the appellant.
May I please?
You are, sir, for the respondent?
Yes.
A.K. Tripathi. For which respondent? Respondent number?
1 to 4.
1?
1 to 4.
1, 2, 3, 4.
1, 2, 3, 4.
Mr. Tripathi, A.K. Tripathi for respondent 1, 2 to 4. So why in a appeal there is additional objection?
But what has notified?
So should it, no, Mr. Mahanti, this exercise has not inured to your benefit or their benefit.
I completely pardon.
So please agree and get the matter remanded. Let there be, at least this pleading should be tried there. Because it becomes endless.
I completely pardon. Well, these
because by converting a appeal to a writ petition, by filing of pleadings, it's an impossible task.
Okay.
So yes, Mr.
May
I am just seeking his response. Mr. Tripathi, I hope you appreciate what I am saying.
Yes.
So what is your response? Kindly respond to that. I have no difficulty.
Because my lord, the third party filed this appeal. According to section 54 of the...
Not there. It could be that third party has filed an appeal. The reason being, yesterday I have taken up a matter. The appellant says the project proponent, the executing body,
yes,
they are not necessary party.
Yes.
Which provision in CPC provides that? That the executing agency shall not be a party, only the officer will be a party.
Look,
even I can tell you the name, I remember that case.
Yes, yes. Yes, my lord.
This court in appeal has to handle that, answer that question.
Yes, my humble...
Unless if you are taking a stand, file that according to you, Haridaspur Paradip Railway Company is not a necessary or the party.
Yes, I have already filed my counter.
No, it's not a
saying that
counter. You show me that, then I can dismiss that on that ground, so that let them challenge it. But you have to be clear in your stand.
Yes.
And that matter is also pending since 2011. Again, a railway matter. Kindly look at the judgment in the land acquisition case, original case.
Yes.
Here.
Yes, LCR also there.
LCR, my brief doesn't show LCR. My paperless brief rather. LCR? Mr. Barik? Madam Achi LCR? Again? Asini. Anyway, just kindly look at the judgment. I don't have any, but let me discuss with you what I mean. Yes.
So,
one to look at collector. Collector is neither the executing authority, it's only the land acquisition collector. Collector means, so he chief engineer East Coast Railway.
East Coast Railway.
So how he is connected with this project?
Because he is the constructing agency.
He's not, if land was acquired for him.
Yes.
So that in finding in the judgment. Straight away come to that paragraph and that line.
Yes, madam.
Mr. Tripathi, that even in your pleadings.
That
because it is a ex parte award as far as they are concerned. I hope you understand what I am saying.
No, my lord.
Again, no, my lord. There are parties there in the.
He is not a necessary party at all.
No, that is fine.
Yes.
Where is the pleading and finding on that?
Because
there has to be a pleading. There has to be a pleading to the effect that yes, the authority who is constructing, he is the opposite party, and suppose and he has answered that. You are saying chief engineer RVNL.
Yes.
Rail Vikas Nigam Limited.
Yes.
So show that in your pleadings.
That only the railway was necessary part. And
No. Cause of action, where you have narrated your cause of action, you can find that. You are the conducting counsel before the trial court.
Yes.
So that from your pleadings.
Pleadings is also there is the
And the written statement he has admitted.
LCR should be my application.
You are the conducting counsel.
Yes.
So you don't have any brief.
Yes, brief is there.
So then how are you saying that pleadings where you have stated? I have. Mr. Mahanti, you pleadings.
No, my lord, I don't have the pleading.
So you examine this. Examine this because they are saying that you are neither in a proper nor a necessary party.
Madam.
So how this person, suppose there is a land acquisition.
Madam.
Appeal filed X versus Y.
Madam.
X says that it has been acquired by Y. I have not received compensation. Y files written statement saying that yes, it has been acquired. I have paid 100 rupees. He says that I am entitled for 110.
Madam.
The court decides. But actually, it is not between X and Y. It should be X versus C.
Madam.
That's your case. So you have to look at the pleadings and whether you have in the appeal you have stated that.
In fact, yes, sir.
Kindly show that.
Your Lordship, my lord, may kindly have my lord, I have filed a leave to appeal.
Yes, it has to be because you are not a. I was asking that, Mr. Tripathi, that it is ex parte award as far as you are concerned. So you have to file it. The leave has been granted. I hope.
No, my lord.
So leave has not been granted.
My lord, what had happened if your Lordship?
No, where in your grounds, because there is a lot of pleadings before the appellate court also. That is how I want to ask you to see that you have stated that.
Madam.
Your answer to paragraph 3, you have filed counter, Mr. Tripathi.
Paragraph 3 of
3-4. Para 3 especially. Unless you are supported by Mr. Tripathi by a Supreme Court judgment, which creates a precedence.
I have relied on 2 judgments.
No,
of the
factually, I am asking you where you have denied that they are not the executing agency or they are not the party. They do not do anything.
In my counter, I have
because you interestingly you have arrayed the contractor as a party. Do you know what a Rail Vikas Nigam does?
No, my lord.
What you are saying? No,
contractor was not the party.
What is Rail Vikas Nigam Limited?
For railway, the land was acquired.
What is Rail Vikas RVNL? You look at your plaint, you are just losing track of it. Look at the judgment. Rail Vikas Nigam is a party. What Rail Vikas Nigam was doing in this whole affair?
Because chief engineer, RVNL East Coast Railway.
What he was doing there?
He was constructing on behalf of.
So when I say, you say no. When you read your the plaint or the judgment, you say that impleading the contractor in a construction contract for any construction is sufficient. Has the court dealt with what was the role of RVNL or any document shown before the court?
Because railway was engaged advocate in the court below.
It's not a question of who engaged which advocate. Whether the judgment has taken note of any material evidence, any record, any paper, any witness who was examined on behalf of the person for whom the land was acquired. Suppose High Court land is acquired. It has been acquired. High Court Judicial Academy. So the contractor is made a party, and the award is passed. That High Court, since has acquired land, so it has to pay compensation. So who has been examined on behalf of High Court? That's the question. It's a roughly constructed example, but I am just making it.
The registry of the High Court is to be made as party.
It has to be a person in whose name the land was acquired.
Yes. Here is the
Maybe-
case, my lord. For the
From the judgment, where do you find? Where do you find that yes, the points for determination you see?
point of determination is whether the petitioner are entitled to receive any higher rates of award compensation. What is the fair market value of the land acquired on the date of acquisition? Whether the petitioner are entitled to any other relief.
Yes. Then where the written statement has been dealt with?
Written statement para 4
Para 4 of the judgment.
is page 2.
Page 2. Yes.
4. The OP number 2 filed an objection. As per OP number 2, the valuation passed by the LA authority is correct. The parties raised no objection while receiving the compensation amount. So now they are asked out to challenge the same. The claim made by the petitioners are not genuine and unjust. For public interest, the present accusation is made. There is no justification to raise the valuation. On the above ground, the OP number 2 prayed to dismiss the case.
Where you are reading? Where you are reading?
In para 4, page 2 of the trial court's judgment.
Look at who is OP2.
OP2 is this RVNL chief engineer.
You are saying contractor.
But he is part of the railway.
Sir, part or not part of the railway, you see, these are serious adjudication. Then you can also be made a party in the petition. They're saying that since part of the petition, why you are not made a party, you are a lawyer. You can be the petitioner yourself.
Yes, I was not the original.
So somebody, so at best, Mr. Tripathi, at best, it's a collusive petition between RVNL contract and the claimant.
There is no.
And interestingly, the magistrate also relies on the contractor's version. Has the contractor paid anything? Has deposited, the contractor has deposited the amount?
No, railway is to deposit.
Where railway is the party?
The land acquisition zone officer party, railway is not party.
Then
this RBNL.
You have not made even the railway a party.
Yes.
No, you have only made the officers of the state who have no business there. Because the statute defines somebody will be a land acquisition collector. The requisitioning agency before the land acquisition officer has not been made a party. And you have made the construction company a party who has nothing to do with land acquisition. You examine the plain. This is very serious.
Yes. So far as
and in some cases, maybe this has to be investigated how these construction companies are being arrayed as party, and the court is not looking at the plaintiff even. Suppose you file a suit against Mr. Mohanty.
Yes.
Effectively, you make Mr. Devraj Mohanty a party. Mr. Devraj Mohanty files a written statement that the should be admitted and allowed. Then what is the consequence?
That judgment will not affect the right of the original.
But Devraj Mohanty is a lawyer. Mr. Satyasruti Mohanty is a lawyer. Both of them are lawyers.
Because according
so
to
that logic should apply.
My lord, this is the case.
The problem is that you make out a case, being a plaintiff, you have to prove your case.
Yes.
You do not know who is the executive, who is the requisitioning authority for whom the land has been acquired. And RVNL is the construction agency constructing everywhere. It's a global. It does a lot of work worldwide.
Railway has not filed any appeal here. Department of Railway has not filed appeal here.
They will not. They will not, the reason being they are not heard. They will challenge it in Supreme Court also. This will not sustain. This will not sustain. After the award is passed against Mr. Satyasmruti Mahanti in a suit, he will challenge it. Your plea will be that since both are Mahanti and both are lawyers, so it should be sustained. You see why for 7 years it is pending. That is how it is pending, because it leads to nowhere. Any amount has been deposited.
No, he has not.
Because you have not made a party. Can you enforce the award?
My lord,
Can you enforce the award?
I have not enforced. I have not
Because
the appeal is pending here.
suppose you want to enforce, how to enforce? Against whom you will enforce?
Against the
Which opposite party? The question is very specific.
only the opposite parties against.
Against who? Opposite party in the original land acquisition case.
Yes,
Which of the opposite parties out of the three you will enforce the award?
2 and 3.
Look at 2.
2 is the RVNL and land acquisition officer is the 3.
Land acquisition officer, does he pay anything?
Through him, payment is to be made.
It is deposited, but does he pay anything? And how you will enforce against 2? The simple answer, the 2 will be, I never requisitioned any land, much less to pay any compensation.
Yes.
The starting point would be that somebody has filed a requisition. It's a public purpose acquisition.
Yes.
And now under the old act.
Yes. Hold on.
That whole process has been completed. The acquisition, the abids, 6 that declaration has been made. 4A, that all this notification and everything. 4-6, whatever. Thereafter, you come and file a case against the contractor.
On section 18.
So he successfully, the award is passed also against the contractor. Can be against contractor. That is the reason. That is the reason. At least the other matter where Mr. Joshi was appearing, he has received with protest. The amount is deposited.
This is the
Whatever. Suppose the court would have given a finding that this amount was deposited by RVNL, the contractor. Then also you could have enforced something. For the
amount
Mr. Tripathi, for the
award was made. Award was preliminarily made, and payment was also made
by RVNL.
No, railway.
That's the problem.
Railway.
That's the problem. You look at your pleadings and the judge. The convenient way to get an award is not to implement. Is maybe the perception is that best way is to not to implement the requisitioning authority. The person who will own the land.
Yes.
Maybe, but it is the most inconvenient way to get a judgment also. Because it can't be adjudicated against somebody who is not made a party. And 2 persons colluding in a petition and saying that if it is not collusion, it's a grave mistake, Mr. Tripathi. Not implementing the requisitioning authority in a land acquisition proceeding is a grave mistake. That I did not want to say. Obviously, it may be taken personally. Apparently, it is submitted by the Learned Counsel for the appellant that they are it is a SPV.
Well, it's an SPV.
They are the special purpose vehicle. For whom the land was acquired for the project Haridaspur - Paradip Railway. That project is Haridaspur Paradip Railway.
Line में लोग देखो.
Railway line. The judgment in LA case number 11 of 2009 passed by the learned senior civil judge Jajpur, dated 7/2/2018, would indicate that the present appellants were not made parties in the said proceeding. State of Odisha, and the land acquisition zone officer cum LA collector were made parties, opposite parties. The executing contractor executing the work of construction of railway, that is RVNL, Rail Vikas Nigam Limited, was arrayed as OP number 2. जो प्रोजेक्ट लिख लेनी ना हो हरिदासपुर पारादीप न्यू रेल लिंक जस्ट तांकर सबमिशन टा रेकॉर्ड करूची so I am not finally disposing of or कौन लिख ले I am recording the reasons why I am not unable to proceed in the matter.
Yes.
In a way actually that is also reflected. कौन लिख ले Para the learned counsel, Mr. Tripathi, appearing for the respondent, submits that OP number 2 before the learned senior civil judge in the LA case had filed his written statement. Though he fairly submits that the East Coast Railway, neither the East Coast Railway nor the requisitioning authority was made a party, as is evident from the judgment, which judgment that doesn't refer to any opposite party as the requisitioning authority or the owner of the land for whom the land was acquired. এটা আইএ কোড আপন লিভ কোড দেখো পুটা ফাইল করছন্তি
Well, that IA number, my lord, 157 at your lordship's flag A, my lord.
Leave
IA 157 of 23. You have objected the leave?
Yes, I have.
এটা আইএ রে পাস করুন IA 157 of 2023.
But counter is at flag Q.
In the count the कौन लिख ले लास्ट कोडी कंक्लूड कर ले क्लोज कर ले acquired hard कौन पर The learned counsel, Mr. Tripathi, appearing for the respondents, refers to the counter affidavit filed by the opposite party, wherein at paragraph 3 it is stated that appellant petitioner himself admitted, flag Q, paragraph 3, that East Coast Railway was the party in the referral court. On the face of the pleadings and the judgment, as would be evident from the judgment, it is apparent that East Coast Railway was not made a party. It is finding with you the paragraph. It is also submitted by the learned counsel for the respondent that East Coast Railway has not filed any appeal. As would be evident from the counter filed on behalf of the respondents. Conspicuously, they have not stated that LA was made a party in the LA case, nor that the present company, the appellant company, the SPV, was made a party. In such view of the matter, the leave to appeal is allowed The IA stands disposed of. तापर लिखंतु LA लिखंतु LA 110 of 2000. आपण ला रे भी कोन काउंटर फिल करले?
No.
से जाए नहीं तो? The admit issue notice delay केते दिन अछि? Delay टा कंडम करे पड़ता पर IA गटे लिखंतु delay
108 days madam.
सेटा IA टा होची 48.
IA number 48 madam.
ला
Flag B.
वो गोटे IA गला dispose of है तापर IA 48 लिखंतु. IA 48 of 2000. The application has been filed for the condonation of delay under Section 5 of the Limitation Act. Delay of about 108 days. The petitioner appellants rely on the decision of this court dated 29/4/2018, passed by a coordinated bench in LA number 47 of 2015 in the matter of Hon'Ble versus Pitambar Sahoo,
I have distinguished.
wherein it was held that the special purpose vehicle is a person interested in the as would be defined under Section 3 into bracket small b of the LA Act, and can maintain appeal under the Section 54 of the said Act.
I have filed.
It is submitted by the learned counsel for the appellant that neither the special purpose vehicle nor the East Coast Railway were made parties, as would be evident from the cause title of the judgment passed in LA case. The learned counsel, Mr. Tripathi, appearing for the respondent, submits that Hon'Ble Sukinda Railway Limited versus Pitambar Sahoo is distinguishable, but he doesn't deny the fact that it is evident from the judgment rendered by the LA collector by the SDG considered as a court natali.
Senior civil judge. I'm sorry.
The senior civil judge, senior division Jajpur, so and so. The respondents chose to make the collector and district magistrate of Jajpur a party, the land acquisition collector OP number 3, and the executing contractor Rail Vikas Nigam Limited, a separate corporate entity, as OP number 3. Though mentioning in the address that Rail Vikas Nigam, in the address of Rail Vikas Nigam Limited to be East Coast Railway. Such mentioning of address of East Coast Railway does not turn out to make East Coast Railway a party. The learned judge also has not delved into the aspect whether any of the opposite parties were project proponents or were the requisitioning authority for such land acquisition. You have filed objection, Mr. Tripathi, to this delay condonation application.
I have filed objection.
Flag, please.
P, my lord. P for Pondicherry.
In the objection filed by on behalf of the respondent claimants, respondents opposite parties to the delay condonation petition is that delay cannot be condoned if the appeal is filed at behest of the government entities rely on the decision in 1996 3 SCC 132. The Supreme Court in the case of blank versus blank reported in blank. Have failed that. In each and every cases, in each and every case, the delay in approaching the court cannot be treated as a straitjacket, and explanations cannot be rejected. It depends on facts and circumstances of each of the case. Yes, you are citing Mr. Mohanty. Any decision?
Well, we have given the state of Haryana versus Chandramani at page 3.
State of Haryana versus Chandramani,
which is a 1996 3 SEC 132.
1996 3 SEC 162.
132, man.
132.
Which says that the expression sufficient cause should therefore be considered with pragmatism in justice-oriented approach.
Para. Chandramani para.
Para 11.
Para 11. In the case at hand, the facts are somewhat striking. The land acquisition is made at the instance of the railways. A special purpose vehicle is formed to execute the project. Neither the railway nor the special purpose vehicle have been made parties before the land acquisition. Not before, in the court adjudicating the LA. The statutory authorities under the Land Acquisition Act, like the collector and district magistrate, the land acquisition collector, who are neither the project proponents nor the requisitioning authority, are made parties. The executing contractor is made a party, mentioning in his address to be that of East Coast Railway. The facts are so glaring that the appeal needs to be considered on its own merits, and applying the principle laid in Chandramani versus State of Haryana. The delay of so days, 108 days, se milhibo ki nahi dekhontu kote amar to kisi korna. Delay in filing the delay of 108 days, seta dekhi kintu lekhibe. Seta lekhibe. Is condoned 108 days. ठीक है, 108 days is condoned. Then lekhantu la. Admit issue notice to the respondents, Mr. Tripathi, learned counsel, who was on behalf of the respondents in the IAs, those have been dealt with and disposed of today.
May I say something?
Please.
LCR is there, so matter will be remitted back to the court below.
No, with observation. Now you gather your thoughts, Mister.
Yes.
You always gather your thoughts. I think I have found out a way for you actually. Because the might of Rail Vikas Nigam and the Railways, East Coast Railway, when there are ex parte order, your petitioners cannot sustain.
Matter be
And this is so glaring that the court, suppose I will not deal with this, they will challenge my order also. In the sense that these aspects that we are not made parties are not taken into consideration. So gather your thoughts. I'll give you a short adjournment, but I'm not getting that LCR. It may be there because I'm since using a paperless court. So if you're having those, you can give it. I can take help from that. Call Lekle. Submits that he has also instructions to appear in the appeal. Upon dekhuchi list re.
No, in the list, it does not say LCR is here.
No, in fact, this paperless court also that bracketed blue boxes, so it doesn't show. So blue box is the link hyperlink where I can reach that LCR. So Mr. Mahanti, Mr. Tripathi says let it be remanded.
No, I will not stand in the way, my lord.
So you will be given that opportunity?
My lord, it had first fallen from your lordship, my lord. On the very beginning, your lordship had suggested that, my lord, I don't stand in the way, my lord, as your lordship.
Yes, Mr. Tripathi. Next week or today, I will pass that order. You gather your thoughts. Don't be in a hurry.
Today can be passed with certain observations so that the matter will be targeted for disposal. Because since 2005, the land was
Mr. Tripathi, to be fair, the claimants embarked on a road to nowhere. The day they decided not to make the East Coast Railway or the, SPB doing the, for who has maybe SPB has paid the money.
Yes.
In all these cases, you see, it is a very complicated financing also.
My lord may observe that
that rail infra financing corporation. What is that?
My lord, it is East Coast Railway along with 6 other private entities, my lord. So all of them have pulled in.
See, it is very difficult.
Government of Odisha is also one.
It is very difficult that in this kind of funding pattern, you simply make the counterparty and the collector. Now, yes, Mr. Swai and Mr. Swai, what is your submission regarding collector and land? I didn't ask them, but they can say we have nothing. They will simply stand up and say that we have no business to construct any railway line. We do not construct. Because the last railway lines they constructed was in the ages of kings of Baripada, Bangripusi, and maybe Parlakimundi, that side, some constructions were made.
So far as this company is concerned, after acquisition, company was formed.
It is very complicated.
Yes.
By with respect, the sub-divisional, what is that? Sub-divisional judicial magistrate first class, chief judicial magistrate first class cannot simplify all these things. That since collector and land acquisition collector party, I am passing out.
No, I'm not saying that. I'm not saying that.
You see, that is how they are not even challenged. They are not bothered to challenge also. Yes. That is a difficult part of it.
If the matter is remanded, then I will include the East Coast Railway General Party.
Whoever, that is not an issue here. The issue is that no one is a party.
Yes.
And at best you can say, suppose the award is decreed against Mr. Mahanti or Mr. Swani, then they will challenge it. That was the indirect question to you, that to enforce the award, against whom you will enforce. That is the other difficult part of it. In fact, the petitioner is the ultimate against nothing, or maybe the sufferer.
I request that without wasting any more time, matter be remanded.
So that I asked both of you. Because in these kind of cases, yesterday, to my good luck or whatever I encountered, today I am the second matter. That is pending since 2014. Sorry, 2011. Yours is?
Well, ours is 2018.
18 is much younger. 2011 LA for this substitution or this that he's not neither interested nor is necessary nor a proper party. Tooth and nail objection by the landowners, land loser. Yes. The appeal. Hard learned counsel for the appellant, the learned counsel for the respondent. କିଏ କଣ ଅଛନ୍ତି ଏଥିରେ appearance ଅଲଗା ଚେଞ୍ଜ ହେଇଯିବ ଲାରେ respondent ହଉଛନ୍ତି Mr. Tripathi for respondents 1 to 4, Mr. Sanjeev Swain AGA for pro forma respondents 5 and 6. In view of the order that is going to be passed in the LA, no notice is issued to the OP number 7, respondent number 7, not OP, respondent number 7, who was the OP number 2 before the learned trial court. Para. The learned counsel for the appellant reiterates his submissions as noted above in the connected IAs. The learned counsel for the respondents submits that the respondents has implicated OP number 2 as the opposite party who had filed a written statement, and he supports the award. The learned AG, appearing on behalf of the pro forma respondents 5 and 6, submit that as far as the payment of compensation is concerned, the collector and district magistrate and the land acquisition collector have no role. They are simply the authorities under the statute. At best, they can facilitate deposit and dispersal of such compensation as prescribed by the statute. Anything else, Mr. That's your submission. Para. Submitted by the learned counsel for the respondents 1 to 4 that since the matter is pending since 2018, the LA case was filed in the year 2009. 15 years have passed. And the present appellants challenge the award due to non-gender of necessary party. No useful purpose would be served in keeping the appeal pending here in absence of the written statement of the present appellants. The respondents would also have difficulty as they have to again defend their pleadings. Those were made in absence of the present appellants. Yes, Mr. Tripathi?
Yes.
Para. The learned counsel submits that remanded with a further prayer that it should be directed to be taken up expeditiously. The learned counsel for the appellant submits that for the ends of justice, he would not oppose such a prayer, and he undertakes that the present appellants shall cooperate in the proceeding if they are implicated as a party. Having had learned counsel for the appellant, the learned counsel for the respondents number 1 to 4.
The court has been bifurcated. The area of
Sorry, could not bifurcated area?
जाजपुर रो जो सिविल जज बाइफर्केशन ने चंडीखोल कोर्ट टा तैयारी ହେଇଛି ବର୍ତ୍ତମାନ ଏ ଏରିଆ ଟା ଚଣ୍ଡିଖୋଲ ଅଧୀନରେ
ଚଣ୍ଡିଖୋଲ ଅଧୀନରେ ଆସୁଛି but I don't know because that would be in the administrative side order, so you don't require. If you have any difficulty, you can seek that file an application. Don't worry for that. I'll record your submission. The learned AGA for the pro forma respondents number 5 and 6. It is directed that the LA is allowed, the impugned order dated so and so, passed by so and so, in LA case number so and so, is set aside. The parties to the present appeal shall appear before the learned court of jurisdiction. The LA case 11 of 2009, then pending before the senior civil judge Jajpur, is restored to file. It is further directed that the learned district judge Jajpur shall assign the case learned district judge or the CJM, public the CJM. It supervising authority CJM thibe.
No, district judge.
District judge.
Yes.
You got in the rank of CJM?
No, district judge, CJM is a criminal.
No. Sabu court CJM dekhanti. Supervising authority, administrative sector CJM dekhanti. But subject to correction, I am not that proficient. But there are two inspecting judges in a district: the CJM and the district judge.
District
judge to sabu dekhibe there. You are right, but the learned district judge shall do well to determine after necessary inquiry the present jurisdiction under whom the case will be decided, as it is submitted by the learned counsel for the appellant, by the respondent, and also agreed by the learned counsel for the appellant, that the present civil jurisdiction is distributed between court,
Civil Judge Senior Division Chandikol,
civil judge senior division Jajpur, Chandikol, ଆଉ କେଇଟା ଅଛନ୍ତି?
Chandikol Jajpur ରେ ଥିଲା.
ନାଇଁ ମୁଁ ବୁଝିଲି ଯେ ବାଇଫର୍କେସନ ପରେ କେଇଟା ହେଲା?
ତିନିଟା ହେଇଛି.
ଆଉ କିଏ?
ଯାଜପୁର ରୋଡ.
ଯାଜପୁର ରୋଡ ବି ଗୋଟେ
ଅଛି.
ଯାଜପୁର, ଚଣ୍ଡିଖୋଲ and ଯାଜପୁର ରୋଡ. ମୁଁ ମାନେ I am not saying that ଏଠିକି ଯିବ. I am saying that it is distributed amongst these three. That's I am observing. ହେଲା. This court appreciates the endeavor made by the learned counsel for the appellant as well as the respondent and the learned AGA in disposing of the matter.
My learned friend may be directed to appear there.
सेटा की कर दे ता पूर्व लिखि दियंतु on ने appear कले difficult कोन हो, he is not a party. LA is restored. The learned counsel for the respondent shall file petition for impletion of necessary party before the learned court that would be in season of the matter after the case is assigned. The learned court, after assignment, shall notice the present respondents number 1 regarding the date, and also as a matter of abundant caution shall also issue notices to the present appellants in the following address. Address ta kaun kahiba?
Is there in the cause list?
As indicated in the cause title.
In the meantime, LAR court has been formed. The government has formed the
LAR court.
LAR court.
Achha.
In the meantime, LAR court is functioning at Kotak, which comes, within which the Jaspur area also comes.
Yes. I mean, I know that in the administrative, so there are some, so for some reason I know that. But let us see, in fact, maybe if you are seeking for LAR, you come up with a petition. Let us not predicate everything because that will complicate the issue. Ita kon lekhne? Actually, dekhibe achi LA 110 re Haridaspur Paradip purata lekhibe.
Only the managing director's name has changed in the meantime, but the address remains the same.
It is submitted by again. Are page 1 more. Cost title re page 1 ko page. It is submitted by the learned counsel for the appellant that the name of the present managing director is Chanchandigi.
Well, I'm not aware, I'll just give it in writing. I'll just give it later.
चले आपण करेक्शन कर देबे एठी जो अछि आपनकर प्रशांत कुमार मिश्र सेटा लिखिबेनी हैला
under the new statute, not old statute.
हां ये could be but let us not predicate से कोन है कि कोड भूल भाल हे जिवो because so no, Mr. Tripathi, since he's practicing there, he knows it. Even I don't know. I mean, old act, it is not there, could be. Yes. So all the petitions say numbers.
2 cases are.
Sir, any other matters that is pending?
No, madam.
At least for you, between you, Mr. Mahanti and Mr.
No,
Tripathi.
madam. These three.
Only three.
Madam, these three.
Other two items are.
LA 110, LA 111, LA 112. All have been listed today.
And everywhere the collector and district magistrate.
Yes.
And the LA collector, they are parties.
Same, madam.
Everywhere, the Rail Vikas Nigam cell is a party.
Yes, madam.
No, I'll check up, but still then.
Yes.
In one matter, the annexes were different, dates were different. So we have been struggling since this education matter.
That matter.
Yes.
My lord, in 111, it is exactly the same. 111. My lord, 112.
IA is same order. And everywhere, IA, as the court master has pointed out, IA you have filed for leave, continuation of delay.
An objection has been filed.
Objection has been
Yes,
filed. Yes.
My lord, and 112 also the same parties.
Same.
1,
Yes,
3,
yes,
2.
yes.
All parties are the same.
Yes.
Now, my lord, in the first case, there was a delay of 108 days. In the second case, there is a delay of 106 days.
That I have instructed them to check up the stamp report.
Yes, ma'am.
And then they will do it.
Yes, 106, 107.
Yes.
Similar cases, ma'am.
Yes. Yes, Mr. Mantri?
I don't know 40.
0. Yes.
But take them after 2 weeks.
Next item number 15.
Just a second, Mr. Mantri, Satyavadi Mantri ngara hochi 40 रे किए अछनी मते कहिबे 2 weeks ओडे डेट करंतु after vacation date करंतु Mr. Mantri, you are not coming to court regularly. I have heard that you are so busy in other works that you are not coming.
Item number 15.
Too much of material, prospects. So difficulty to handle it. Spending time there. Yes, Mr. Swati.
Item 15.
Yes.
Next item.
Yes.
Whatever up to the another matter is fixed, may be taken up as the last case today.
Passover. You are playing
Passover. I
Passover.
pray only for Passover.
Mrs. Mahanti, he prays for a Passover. Will you wait? Or you will, no, it can be taken up if you want a date. Passover. So after return you join.
After lunch,
Yes,
so
yes, yes,
finish
yes.
up,
Yes.
come back.
Yes.
Item 16, my lord.
Once
The opposite parties, I pray for 2 weeks time.
Tibrewal,
I am for the petition, Lord.
your name, sir?
Abhay Khandelwal.
Mr. Khandelwal, Mr. A.P. Rai,
Tripathi.
Mr. N.D. Tripathi.
Yes, ma'am.
ND stands for
Nigam Darsi.
Nigam
Darsi.
Nigam Dutt Singh.
Darsi.
Nigam and Darsi. Achha. When do you want, sir?
2 weeks, ma'am.
2 weeks to पड़ेला आपनकर छुट्टी पाक पड़ेला last week.
Again.
After vacation ना 2 weeks पर रखिबे.
Before vacation.
ताले give to date को जल्दी करंतु. 14/5 है.
Item 32 में item 32.
Adjournment.
Again.
How much time, sir?
1 week only.
Date करंतु 1 week, Mr. Barik.
Pleadings are completed. Both.
2/5 will do. Or you want further time?
My lord.
2/5. 2nd में ना अधिक time.
7th में.
7 में. 7 में ठीक है.
My lord, item 22, my lord.
Again?
Item 22, my lord.
22, yes.
My lord. I pray, my lord, after vacation, my lord.
You are for?
I am for the petition.
For other side?
Other side given consent, my lord.
Sita.
Sorry.
Privately, I can't mention consent. So.
Aye.
After vacation कहउचंदी.
After vacation.
आपन नाम टा?
Priya Ranjan Mishra.
If they agree, I will be granting, or else it may come up tomorrow also. Unless there is a consent in the presence of the court, please don't mention. Otherwise, I shall pass that order. I have noted. Yes. Yes, Mr. Nanda?
Item 21.
21, yes.
In the morning, the petitioner has made a prayer for accommodation for the day.
Yes, yes.
So, your lordship
Date?
29th. Because
Before vacation or after vacation?
for vacation 29th, I pray.
Before vacation, what date करंतु? 30. 30/4.
29th will be.
नहीं 29 you have 30 difficulty अच्छी. Out date कही दियो मतलब 1 week after से कही थिले तो 6 तारीख
7th of May.
7/5. Yes.
Sir, item number 33.
Question for tomorrow, sir.
Again? More I am not sure. If it reaches date କରନ୍ତୁ ତାହେଲେ କୋଉ ଦିନକୁ ଦେବେ?
Tomorrow.
2-5 20 ଆପଣଙ୍କ ନାଁଟା କୁହନ୍ତୁ item 33 for whom?
On behalf of Vibhuti Bhushan Mishra, petitioner.
Ananda
Sagar Patra.
But you see the other side is not there.
Yes, sir.
If they object, it will not be urgent. After notice matters, I can't. I am noting it.
Yes, sir.
In good faith. Yes.
Item 20.
20.
And I am ready, but I may be in difficulty. If you are not permit, it may
other side, Mr. Union. Union say they'll be happy.
No, it will be tomorrow. I am pressing for tomorrow.
Tomorrow may be difficult. Because these are after notice matters. There will be some leftover. So
if it just may be possible.
No, you take a date. Could you date kar jaldi karantu 20. 5 মানে আগুর না পরে 5 আগুর কেউ চল আগুর 2-5 yes rest of the matters after recess. Thank you. Yes. Password ଗୋଟେ ଅଛି ଦେଖନ୍ତୁ ହଁ
Item 16.
Mr. Abhay Khandelwal for the petitioner, Mr. N.D. Tripathi for the opposite party. 'plural'. It is the learned counsel for the petitioner seeks accommodation. As read for list on 14/5/2025.
17.
Yes. 17 is my assignment. This is relating to
Service matter.
Service matter.
Matter relating to service.
service matter.
I have filed a
Service relating to other than education. Yes.
here I
Kindly speak to the microphone, Mr. Nanda.
Microphone.
Speak to the microphone, please.
whereas in this case we have already on 19/8/2014
Yes.
the affidavit was filed.
Yes.
In corresponding to an order.
Just speak to the microphone. Actually, the speaker is away from you, and more so when you are appearing for the speaker in the legislative assembly, you should speak to the microphone.
Plus, there is an order 4/8/2004. To that, we have filed an affidavit that is already on record before your lordships.
Yes.
There we have already taken up the issue and everything has been released, all paid as such. Now, my lords, he is claiming the promotion, notional promotion. So I
you kindly refer to the order again. Order dated
4/8/2014.
4/8/14. To comply with the order dated 6/8/91 passed by this court in OJC so and so.
My lords.
So you have filed affidavit indicating compliance.
Indicating compliance.
That is affidavit dated?
Affidavit dated 19/8/2014.
Right. Thereafter what happened?
No. Now that he is claiming the notional promotion on that issue.
Is it a original prayer in the writ petition?
No, no. In my read petition, I have prayed for the promotion.
Notional promotion?
Yes.
Yes.
No,
Yes.
not notional, but promotion.
Promotion, but
Promotion
I have to.
Petitioners joined.
When antedating your promotion?
Yes, my lord. At that time,
No. Kindly let's confine to the issue.
Yes.
You are seeking promotion from a particular date or from a particular date with notional benefits?
From the date juniors have been promoted.
From the particular date. You have been given promotion from a date
I have not promoted.
yet to be promoted.
I have retired from the service. In the
Then
meanwhile.
you have copy of the order dated 21/8/14. You are having with you, Mrs. Ponda.
21.
8/2014. 21st August. Mr. Barik, find out the file. You can scroll in that paperless. If you have it, order number 17 dated 21/8/14.
I am not acquainted with this system.
No issues. I mean, you'll be much better acquainted. If the she will do it for you. More दरकार नहीं. आपण नहीं देबे छोटी. से शिखी जाई थांते आपण तो कागज दे दे.
नियंत्रण.
Order number 17, 21/8/14.
17.
This is this.
Ms. Ponda, appearing for the petitioner, Mrs. Ponda rather, submits that the additional affidavit and the enclosures filed in the court today, for which she wants some time to verify the position from the clients. If necessary, she may file objection. Just prior to that, from the beginning, because I pointed out your stand. OP number 1 files affidavit dated 19/8/14, indicating that therein the authority has called 6891, passed in OJC 4050 of 1989. He has also filed office orders in compliance with order dated 6891. So have you responded to that? As undertaken on 21/8/14, that is your submission. I was drawing your attention.
Yes, I have filed an affidavit, my lord, on 19/8/14.
It could not have been.
After 21.
It could not have been 19/8/14. Please mark the date. 19/8/14.
19/8.
Yes, reply to the affidavit filed by the opposite party on 19/8/14.
So that affidavit is?
That affidavit I have filed on 2/9/14.
You have served copy on the Learned Counsel, Mr. Nanda? Then Mr. Burma was appearing.
But I have not.
Probably I have sought, my lord, but no receipt is in my.
You have 14. This is affidavit by Ganesh Chandra Panda.
Again, this is a petition.
You have that, Mr. Nanda?
No.
Since there is a change of counsel, either you provide him or he will make photocopy from your brief.
I will provide.
So because since 2009, at least we have covered up to 2014. 2014. So let us not spend time from 9 to 14 again, relooking the whole thing. If anything, you agree or whatever is there deficient according to you. So the appearance dakini. Mrs. Madhumita P.K. Nanda. Sunil Kumar Nanda for the opposite party. OP number 1, Mr. Devaraj Mahanti, AGA for OP2. The Lord Counsel for the opposite party refers to the order dated 14/8/2014. Passed by division bench of this court. Uh, 4/8/14. 4/8, not 14. 4/8/14 passed by a coordinate bench of this court. To submit that by the said order, the following was directed. Quote kar dele. Thereafter, I was referring to the order dated. Now I have again missed it.
21/8.
Sorry?
21/8.
21/8.
21/8. Thereafter, by order dated 21/8/14, a coordinate bench observed the following, directed the following. Quote kar dele. Mrs. Panda, Learned Counsel, submits that as undertaken in the order dated 21/8/14, the petitioner has filed affidavit in reply to the affidavit of the opposite parties dated 19/8/2014. After serving copy, they are the Learned Counsel for the opposite party. Para. It is submitted by the Learned Counsel, Mr. Marika, that since the opposite party number 1 has obtained a change in, he may be provided with another copy of the said affidavit filed by the petitioner dated 2/9/14. Para. How much time, Mr. Nanda?
2 weeks, my lordship.
Already 15 years, Mr. Nanda, you sort it
Your
out.
lordship, on the 7th of.
I think Mrs. Panda, suppose you get, since you have retired, you can't rejoin the post. So in a way, now I comply that you get all the notional benefits, fixation, everything, seniority.
Yes, my lord, my lord.
So if so, there is no, there is no further litigation out of that. That may not be.
Yes, my lord. My lord, what happened?
You have attained the age of superannuation. So now, Mr. Nanda, you obtain instruction that suppose he's saying that a person junior to him has been given from a date. Even if you are giving him the notional benefit of promotion from that date, there will be much less financial burden because you will not be paying the differential you may pay. And if to be fair, you have to pay the differential. And last, fixation of the salary. Fixation of the salary, that can be done.
I will take it.
Yes. You sort it out.
Post it on 7th May.
As the time has taken its course, the things are fizzled out. Please appreciate that. Yes, Mrs. Panda. You are saying something.
I only pray that the petitioner join in the post of diarist and retired in the post of diarist after serving 29 years to the department.
By that particular date when you filed the affidavit, he had retired.
Yes. 2012, my lord.
So that is how the beyond 2012 filing of this affidavits will not improve. You should have reconciled then actually, Mrs. Panda. You should have proposed this, that since the day I have retired, I have to, now I'm reconciled with the position that I could not. So whatever notional they will give it, to make a demand for that.
It is possible.
That is I am praying, my lord, if that can be
Yes.
directed, then.
But as prayed for, ता पूर्व लिखी में during here, as the matter was had to, when the matter was had to the notice of this court that the petitioner has retired on attending his of superannuation on in the year 2012. In considered view of this court, after the date of superannuation, the petitioner can get only notional benefits. The opposite parties as a benevolent employer may consider this as far as his prayer for giving him promotion from the date on which his immediate junior got promoted.
That this may not be a case because what instruction I do have that in a DPC, the promotion could not be given on merit. There are senior people, those who have been promoted. For that reason, it could not be promoted. That is what the limited.
Haji challenged the DPC finding.
No.
That DPC, that the pleading of DPC has not been mentioned in this counter, my lord. They have and DPC.
ठीक है, let us not join issues today. Let you not join issue today and
because we have paid after this judgment.
You look at to the response of the petitioner,
exactly,
which she will provide.
Exactly. Your lordship in that line. They have given the reply. I will either reply or I will come with some order.
No. It is only observation. So at best is pious observation. I have not directed anything because I already said that you require a copy since the OP has obtained a change. Yes, change in counsel. Next, please. How much time?
Your lordship proceeded on 7th of May.
9th?
7th of May.
7th of May. 7th. Will you be obtained in instruction by 7th?
Yes, I will.
7th of May.
May the other matter that also be placed because when OJC number 4050 of 89, that will be very easy for. Let it come.
OJC.
That was the order that has to be complied. That rate application.
Asu, order to achi. No order to nahi hai.
Total order nahi.
The records of the connected OJC into bracket scan copy. OJC number ta kahile author?
OJC number 4050 of 1989.
4050 of 1989 disposed of on?
That is also Miller's. They're trying to
6891.
6891.
1991. Be placed for reference. Yes, next.
18 may I please be your lordship? I am in wishing mode, my lord. My lord, 18 is
Mr. P.K. Mishra for the petitioner. C. Das for the opposite party. Yes, Madam Das. Mr. Das is seeking for adjournment because of difficulty. The learned counsel for the opposite party submits that he may be accommodated due to personal difficulty and prays for 2 weeks accommodation as prayed for. List after 2 weeks would a date diyantu.
Exactly.
12-5-20-25.
After vacation.
After vacation eve कहलेनी. As the day progresses, the difficulty.
No, my lord, short date may be fixed since the petitioner is suffering.
In the morning it was 2 weeks. Now it is vacation. So in fact, it would be last week of vacation because there's no.
It may be after 2 weeks. My lordship take into matter.
I have no.
Hopefully the difficulties will decrease by that. 2 weeks. 12-5 कर देना. Yes.
Grateful.
Yes. Mr. Surendra S.N. Ponda for the petitioner.
My lord.
Mr. Vivekananda B.N. Udgata for the opposite party. Why so many connected petitions?
These are all, infectious. They should have been delisted.
No, not necessarily. But it's connected because
It is related, my lords. Related, and it is necessary also at the time of hearing. Also.
Yes, Mr. Panda.
Uh,
So SN Panda for the petitioner, Mr.
I pray, my lord, can I be permitted to submit the facts before the actual
No, first, you please come to the what is the impugned order, what is the prayer.
Mine.
Let us start from there.
Impugned order is Annexure 11, page 39. Page 39 to 40 of the writ petition. Annexure 11.
For what?
Yes, my lord. But fact is,
Claim for what? This
terminal benefits. Actually,
terminal benefits.
the petitioner.
My lords, your lordship, just have a glance to the first order that is dated 18 to 2016, my lords.
Yes.
Minutes. Hard Mr. S.N. Panda, Lord Counsel for the petitioner. The petitioner filed this application claiming for interest of the amount disbursed to her after 7 years of acceptance of resignation and also bank contribution towards pension benefits. It is stated by Learned Counsel for the petitioner that the petitioner is not entitled to get any pension as she has resigned from service. Therefore, the claim made to that has been forgone, and the only claim made by the petitioner is that bank's contribution should be disbursed in her favor.
Yes.
My lord,
This is the-
this is not the final court order.
No.
My lord.
Sir, final, semi-final or quarter-final is not the issue. It's a
My lord,
court's order.
Coordinate.
Sir, I cannot treat a order of the court to be semi-final or quarter-final.
My lord, I am submitting.
So you have to challenge that order or seek a review of that order.
No. Submission is coordinate bench has modified this order and by subsequent order.
Let me come to that.
Yes.
Again, Major.
Why we are saying final, not final?
16, 12, 24 minutes. Your lordship, just a glance. Then minutes, your lordship, just a glance to 16, 12, 24.
Yes, I'm just going.
Minutes.
Since there is a modification, he's saying that.
Yes.
Amendment was filed. Amendment allowed.
So accordingly,
No, amendment not allowed with permission. Yes. Really, in this case, from the shade or may I read?
Consolidated 27/6/17.
That is in respect of amendment of cost minutes because the petitioner expired during the pendency of this case. Ultimately, Millers repented through her husband and this son Millers. That much allowed Millers. But in respect of the order Millers, she has paid for Millers modification, and by virtue of the order dated 16/12/24, it has been clarified. Millers.
Mr. Poda, 2419 order you are having?
Yes.
Can you look at 2419? You can see in the paperless brief.
My lord is asking 2419 order.
2419. I may submit it. Mr. S.N. Panda, Learned Counsel for the petitioner will satisfy the court that on relinquishment of job, the petitioner is entitled to get all benefits as due and admissible to him in accordance with the staff rules. Thereafter, my lord.
There is no thereafter. Let him produce.
Ah,
Let him produce the rules indicating the fact that the petitioner is entitled to get all the benefits as he claimed. So basically, you have a claim based on certain rights accruing to you, based on certain.
Yes.
I mean, it's a employer-employee relationship guided by some fundamental rules or.
Rules of the bank as well as
So yes, you have averred that in your petition.
I have submitted. To, and copy also I have handed over to opposite party bank advocate. The long back I have submitted, giving exhaustive rules, copies, and everything.
No, but which part you rely on? You can refer to that.
No, my lord. This I have not got that file because there is a copy.
No.
Certainly. That in compliance with the court order, I have submitted detailed.
Then there is an order dated 16/12/19. Thereafter, you look at order dated 16/11/22. You require any assistance, Mr. Ponda, to go through that, or you can see it yourself.
Right.
You use that.
No, I do not know.
ठीक है सेटा ठीक है जाके ठीक है ऑपरेट कर देंगे. Sixteen 12/19 गोटे देखो तो order number 25. Sixteen 12/19 order 25. Learned counsel for the petitioner shall file an affidavit with regard to the leave of encashment and benefits, excepting the pensionary benefits, after serving a copy of the same on the learned counsel for the Eco Bank, for enabling him to obtain instruction in the manner.
Yes, I have supplied. I have also complied.
That affidavit has been filed.
Yes. Yes, I have supplied.
When did you file that affidavit?
Well, no, it is a not affidavit. It is a list of bank's rules along with the claims.
Look at 16/12/19 order.
Yes.
Your submission.
Yes. The learned counsel for petitioner shall file an affidavit with regard to leave in. I have submitted. That within 7 days, 7 days. I have got the copy, but I have not got it. I have with the court. I have submitted before the court copies also
No,
have.
I am not disputing whether you have submitted or not. I want to see that affidavit.
Yes.
So that if it is part of the record, I can find it out.
Yes.
That is the purpose of asking you.
That presently I don't have.
Then just kindly look at the order 16, 12, 19. Then just scroll down for the order dated 16/11/2022. Order number 33. 33. Para 4, yes, 16/11/2022,
Yes.
order number 33.
I
IT was filed for modification of that order.
My lord.
Dated 16, which we both all of us were referring to.
Yes. The application has been filed by the petitioner.
Order dated 18/2/2016.
Yes.
After some arguments were advanced, Mr. Pandal, learned counsel appearing for the petitioner, states that the petitioner may be permitted to withdraw this little application with liberty to file a fresh.
Yes. That also has been filed.
With better particulars.
Yes.
That when filed.
That is that another modification was filed on that is IA number 7539 and 7291 of 2023. The date is it is the matter was before coordinate bench. So there I have submitted.
No, sir. The coordinate benches of this court do not deal with different files. Judges only change. So if it is on record, you have to refer to that so that I can also look at it.
But this is para 5, 2nd April 2019.
Look at again, just latest order, you can say. Scroll down, please. Order number 37. Or dated 16/12/24. Para 6. Para 6, that is internal page 3 of the order.
6.
Yes.
From the said orders.
Yes.
Passed by the coordinate bench. Read with the prayer made in the writ petition. It is well evident that so far as the first prayer made in the writ petition, the same being regarding bank's contribution or pension, so far the alternative prayer for pension was forgone by the learned counsel for the petition of right order dated 18th February 2016. Hence, it is made so far as other prayers made in the writ petition, the same remains to be adjudicated in the present list, and there is no need of pass any further order for correction, clarification of that. Because the Honorable Court coordinate bench.
No, I don't want any explanation regarding what happened how the judge. So you see, there is no change circumstances or scenario that I will revisit those orders. Please appreciate that. As a judge, I continued as if I am taking up the matter as it is that was on the order passed, that is 16/12/2024.
Yes. So they are permitted.
So now again there is no scope of reopening that order.
Only by that order?
18 to 16. 18 to 16 order has been visited thrice. Then again by the same bench which dealt with the matter on 18 to 16. On a subsequent date, as I have shown you, order number 33.
Yes.
Again, order number 37.
Yes.
So now, so you have to please confine to the prayer because till the matter is kept pending,
Yes.
the petitioner has passed away.
Yes.
She was thinking something would happen. Now the legal heirs will start thinking that something would happen. So what remains? What remains?
As per the prayer, I may kindly allowed to place the prayer?
No. There's no difficulty, sir. I am not preventing you to place anything. But what according to remains after these three orders?
Yes.
What you can do, you can prepare a simple, not affidavit, I am not saying. You can prepare one paragraph, what remains from the prayer. Exchange with Mr. Bhuya. If you both of you agree so that I can proceed. Because again, after 9 years, we are still whether 18, 12, 16 order can be passed, could have been passed 18 to 16 order. There's no point. After 18th of February 1916, we have crossed 18th February 2025. A decade.
Only prayer, what is there list of the unpaid?
So you have the choice, obviously, as the petitioner, you specify after 18 to 16 order what remains as far as your prayer is concerned.
Yes, my lord.
And I am sure Mr. Bhuya will have no dispute regarding that if it is there. But let us not, vacillate that fish around, like what would be the prayer, what could be the prayer. Please appreciate that.
Now kindly come to writ petition page 10.
No, sir. I will adjudicate the matter.
Yes.
Now the question is, 10 years have been taken by the petitioner to present the court what is to be adjudicated.
Yes.
Please don't, make a party to that process again.
No, that has been allowed. Modification has been allowed.
No.
By which order, sir?
By that latest order.
Not it is. My lord. There is no need to pass any further orders for correction, clarification of order passed in order 18.
That is the third order, sir.
The 18 order.
Earlier you said that the IA was allowed. Yes. I have shown you the order number 33, where the same bench which considered the matter and passed in 2016 has said that the IA is withdrawn and will find another IA.
Okay.
Thereafter, another IA has been perhaps filed.
Yes.
There, that was taken up by order number 37.
Yes.
And the order I have read to you.
Right. Correct.
So now please confine here that what prayers remain after 18 to 16 order. You confine and argue on those prayers. Let us adjudicate that.
Same prayer. Whatever is writ petition, same stands.
Then let us be dismissed.
Where is dismissed?
Mr. Ponda, you have the advantage of looking at the replay. What I am saying, what you are saying, everything is again played. After these three orders, if you insist on those orders, then the writ petition has to be.
I'm not insisting on those orders.
So please prepare a short paragraph of what remains in the writ petition.
Okay.
Can you do it now?
That is same thing as what I have told in the writ petition of my averment is there. Same, all the list of the issues which have remained unpaid by the bank for terminal dues, I have been listed.
Mr. Ponda, if you are serious, I'll record that. I'll record that and dismiss the writ petition. And you have the advantage of replaying the whole thing and considering what you have stated and what the court has said.
My lord advised me that...
No advice. I have left. After elevation...
I have to list out the issues.
No.
I don't...
Never. I think my English is not so poor that to confuse you. I have shown you the three orders, 18 to 16.
Yes.
You can write it down. I have shown you three orders, 18 to 16 order. Again, I'll repeat. (18 to 16 order), then order number 33. I'll upload this. I'll upload this, Mr. Panda, so that, yes, Mr. Misra.
No, your lordship is correct, my lord, your lordship. I was just telling him, your lordship is correct.
No, I mean, Mr. Panda, request Mr. Panda, so let me inform you that proposition, that at least he should have the satisfaction that he has presented the prayer.
Right.
So after 18 to 16 order, then 16/11/2022 order,
Right.
thereafter order number 37.
Right.
That is order dated 16/12/2024.
16/12/2022.
In his prayer, as far the prayer is concerned, because in fact, Mr. Panda, all three orders do not preclude you from agitating the other matters. But since 10 years, the order was passed 16/12/20 order, 9 years rather, 18 to 16 order. You have been IAs after IAs taking adjournments to justify that you have other surviving claims. You could have challenged that order and got an appellate order, that's a different thing. But in this writ petition, we are now going to complete 10 years.
I'll satisfy my lord.
No, it's not I'm not at all saying that I am not satisfied with the writ petition. But it is very difficult that to settle a prayer in the writ petition after 10 years.
No, it is settled. I will commit it, can allow me 2 weeks time. I'll say.
No, not 2 weeks, sir. It takes either if you do not refer to anything.
No.
Suppose you make a extempore submission. Do not refer to any pleadings. Do not refer to any order like I am doing. It becomes endless. We must understand that we are bound by the pleadings,
yes,
by the response and by the orders.
By the order, right.
By simply change of the bench is only a continuation.
Yes.
Actually, I did not have to elaborate. Since Mr. Ponda, you are again and again saying the same thing, I have to dictate that order.
I pray my lord, can this order 2nd April 2019.
Sir, 2nd April 2019.
They have categorical.
Mr. Ponda, 2nd April 19, you did not submit. I have pointed you out.
My lord.
Please appreciate that also. There also, I have not sought any got any assistance from you. Apart from saying that the entire prayer remains.
Yes.
Mr. S.N. Panda Likla appearance. Mr. Manoj Mr. Senior Counsel instructed by Mr. B.N. Udgata for the opposite party. The case presents a very unique scenario where the prayer made in the writ petition the prayer, no. The contents of the prayer made in the writ petition are still discussed by several orders of this court in view of the stand taken by the petitioner on different dates before different benches. On 4/2/2016, order number 2, the following was there. Mr. Panda, actually, this is an effort to assist you only.
My lord, I'm glad to oblige.
No. I mean, since you are once I say something, you say something else. So I only to assist. So as I said that I should not, but I am assisting you. Order number 2 dated 4/2/2016, quote kar dele. Then order number 3, 18/2/16. 18/2/16. Yes. ଆପଣ ଗୋଟେ caption ଆପଣ ବସନ୍ତୁ, don't stand, ବସନ୍ତୁ. That on the dates, the orders and the dates indicating the Learned Counsel for the petitioner and the orders passed therein are reproduced herein. 6251 of 2017. Any idea, Mr. Ponda? It is your petition. 6251 of 2017 was filed for?
That was for
Anyway,
direction in
ଆପଣ ଗୋଟେ କାମ କରନ୍ତୁ, just
representation ଥିଲା, that is a because
just write miss case लिखी blank छाड़ दियंतु, miss case 6251 of 2017 ହେଲା ଏବେ जो जे लिखना ଥିଲେ कि कोर्ट कले दिटा ऑर्डर तापर 6251 of 2017 just leave it there. Prayer for amendment 73 is substitution, Mr.
yes,
Yes, Udgata.
Yes.
Well, that's not necessary. Substitution has to be allowed.
Yes. It is not allowed.
Order number 22, dated 2/4/2019. Order number 25, dated 16/12/2019. Then order para, then order number 32, dated 14/9/2022. Order number 33, dated 16/11/2022 in IA number 12690 of 2022. Then order number 36, dated 26/11/24. Order number 37, dated 16/12/24. Lauded counsel for the petitioner, Mr. Ponda, is requested to prepare a note and circulate the same.
He himself is the petitioner, not the. He himself is the petitioner. He is appearing in person.
Oh,
When
I'm
I
sorry.
said counsel for the petitioner, he himself.
Yes, I was thinking, but I could not locate the name actually. It was Minakshi Ponda is.
His wife.
Oh, acha.
Mr.
Ponda, then you should engage Mr. Mishra should have been at your shoes. He should have been. You should have engaged Mr. Mishra and Mr. Udgata. It is very difficult. It is very difficult, and I was thinking, but I could not. In fact, I marked also as going to ask. Then I somehow, because of this series of orders for 9 years, I marked that you are not wearing the band. Petitioner in person कर देवे, है appearance में सबूत भी. Learned counsel जोड़ लिख ले, petitioner in person. He is requested to go through these aforesaid orders, particularly first order जोटा गोटे था, कहती, then order number 33 and order number 37. कह देवी आउथरे. And prepare a paragraph indicating the surviving prayer in the writ petition. He is also requested to circulate this, give a copy of the same to the non-instructing counsel, Mr. Udgata. If list kebe chahunchati Mr. Ponda. At the list on 8/5 on consent list 5/20/25. Mr. Ponda, the effort is that once you pin down that,
yes,
I think Mr. Udgata and Mr. Misra will do the rest. If anything is there, because there have been some orders actually. I get this hint from the earlier orders. Justice Patnaik's order, Justice Sodangi's order, and whatever is left out after that, simply they will work it if it is possible.
Is it by way of affidavit?
No. I have not said affidavit because I am only confining to the prayer, not delving at all into the facts. That is when you said that you look at paragraph page 10 or that annexure, because we are still in a stage where the prayer is yet to be settled. And since you have not challenged those orders, earlier orders, and much water has flown, you must also accept that. I mean, appreciate that also. List on 8 and 5 है बरे? 8 and 5. Sub item, Mr. Sub item रे कौन करिए? Mr. Pondas?
Sub item, these are all infructuous. You have no link with this.
अच्छा ठीक अछि. Sub item में खाली से tag up तो ही को अच्छी होगा. तले order दरकार नहीं.
Yes. It can be referred at the time of hearing.
Yes.
Okay.
Item 20.
Mr. Augusti Kanungo. Petitioner? Anyone for the union? Opposite party? None? Learned counsel for the petitioner seeks that the matter may be adjourned. He has some personal difficulty. As prayed for, list on 2-5-25.
21.
Mr. Tarun Patnaik, on behalf of Mr. Subir Palit, Senior Counsel. Mr. P.K. Nanda, for the opposite party. P.K. Nanda designation? Senior Panel Counsel. Any idea what is the designation of P.K. Nanda? Opposite party लिख दें तो designation लिखों तो नहीं. The learned counsel for the petition submits that in absence of the senior arguing counsel, the matter may be adjourned. As prayed for, list on 7-5-20-25.
Item 22.
Mr. P.R. Misra for the petitioner. Opposite party blank. Learned counsel for the petitioner seeks accommodation. As prayed for, after vacation, got a date कर दियो तो. As prayed for, list on 24-6-20-25. Yes. Yes.
23, may it please your lordship.
Yes.
This is an appeal under section 20 of the Coal Bearing Areas Act, 1957, my lord. The appellant,
so that commission,
the tribunal, my lord.
Tribunal has passed order.
My lord. Tribunal has passed nil award, my lord. Against that award, my lord, I have come before this court. The short question involved in this case.
There is a coal bearing, that commission is there, headed by district High Court judge.
Commission for the
Kindly speak to the microphone.
The 14 villages in district of Sundargarh. But other part is coal bearing tribunal is there. One is Jharsuguda, another is Talcher. Talcher is a full-time tribunal. In Jharsuguda, there is a district judge come part-time tribunal. District judge in charge of that.
Talcher also district judge, full-time tribunal.
District full-time. As per the notification.
Notification.
My lord.
So it is against the order of which particular Talcher?
Talcher.
Okay.
And acquisition.
You are Mr. A.K. Urta.
No, my lord, my power is not there. I am.
Your name, sir?
My lord, Prabin Das on behalf of Mr. S.K. Das.
Mr. Prabin Das. P-R-A-B or V?
B-I-N, my lord.
Das, D-S-H.
D-S.
On behalf of Mr. S.K. Das for the appellant. You are there for?
For respondent 8 and 9, my lord, MCL. Veda Prakash Ponda.
Mr. You also write B or V?
B, my lord. B for
Mr. B. Ponda, Veda Prakash Ponda. BP Ponda you are writing?
Yes.
The BP Ponda for the respondent.
8 and 9.
8 and 9. Mr. Devaraj Mohanty, AGA. Acha, sorry. Pradhan. Please kindly just again tell your name.
R. Pradhan, my
Mr. R. Pradhan. Pradhan, full name is?
Rajdeep Pradhan.
Rajdeep.
My-
No, today morning also I have dictated. I'm sorry. R. Rajdeep Pradhan, Additional Standing Counsel for rupees 6 and 7. Yes.
Milord. Milord, the appellant being the petitioner has
Yes.
filed the application before the tribunal under section 14 of the act, Milord.
Yes.
And the learned tribunal,
ये जो act वही उड़ा के ठीक अपन coal bearing लिखंतु coal bearing areas please लिखि रख दियंतु सेटा सार को फेरे देबे हमर ने से बहटा थिबो कि एपड जदि खोजिबे थिबो coal bearing areas acquisition and development act 1957. So Mahanti, that is the only act or any rules are there also?
No.
Achha. Yes. Mrs. Mahanti, that urgent matter you are, you will wait or? Okay. Yes. 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 I'm sorry. Passed over matter. It was passed over by Mr. Swine. Yes.
Milord, after not getting compensation from the authority, Milord, he
Yes.
has approached the tribunal. The tribunal has decided that as there is a dispute on the title,
Yes.
and this tribunal cannot go to the question of title, so there is no question of any compensation to be granted to the petitioner.
Yes.
That
So
was the
the
only
amount has been deposited.
Amount has been deposited
Yes.
by the MSHL authority before the Tahsildar.
Yes.
That they have stated in their counter, Milord. Affidavit, Milord. So now the question before the authority was whether the petitioner as having the title or not, Milord.
Yes.
So that the tribunal only decided on the point that this tribunal cannot go beyond section 14 of the act, and section 14 does not permit the tribunal to decide on the title, and subsequently dismiss the matter, and nil award has been passed. No award has been passed. Against that order, Milord, I have come before this
No,
court.
can it be said that it's a case of nil award? Because the amount is to be disbursed.
Milord.
So how can you say that it's a nil award?
Milord.
Yes, what do you say?
It's a government land. Record stand for the.
It's a government land.
Government.
Yes, ma'am.
And his client said that his encroachment case has been initiated and land has been settled. And you'll also call for the record from the Tahsildar. Tahsildar stating that encroachment case has been registered in the name of private opposite party hearing.
Some other person other than petitioner.
But no land has been settled in any favor. But encroachment case was there in favor of the private order. And he has filed certain document that Tahsildar has denied. We have filed that affidavit in that.
The problem is that let us for a moment get out of this coal bearing or the regular land acquisition act. This question I had occasion to learn in the.
Milord.
I mean, learning law as a lawyer and a student or whatever you say. We continue to. Somebody said that law students and students of law. Law students, now I have become a student of law. So why ROR?
Milord.
Why record of right? Why record of right? Why not any other document? Perhaps while exercising eminent domain, the state has the power. Coal bearing act, the same thing, eminent domain, and it's since it is a special mineral, it's a special statute, expedite the process. But recorded tenant is paid the amount. The reason being the most shortest possible way to determine ownership. Because if any other method to determine a ownership of a land beyond record of right, revenue record of right particularly, is a suppose somebody will rely on a sale deed. Without the argument is this: I have purchased a land, or somebody has purchased, X has purchased from Y, still remains in name of Y, not mutated. X, the purchaser says that even if I am the bona fide purchaser, still I am not getting the compensation. It's a hypothetical example. But the endeavor or the aim of the statute is that the person whose name is there, maybe through him, that's another thing. And here it's a very peculiar case. What is the kisam of land?
Government land.
Anavadi, Rakhit Anavadi,
or jungala, or what is the kisam of land?
Admittedly, the petitioner is staying at this place.
Occupier, no, that is what I was trying to understand. As far as your structure is concerned, you may be paid. Your trees, you will be paid.
Only cost of the structure.
Cost of structure, trees, other things. People have got substantial and handsome returns as far as government lands are concerned. Panna Boroja, that tree and fruit bearers, this Panna Boroja, and other thing is that ponds, fish ponds. So it's possible. But as far as the compensation regarding the land is concerned, it is only the recorded tenant or the revenue record is in whose name.
But I got that point, my lord. Now the
other part is that suppose you are claiming through that particular amount attributable.
My lord.
Because it is not a compensation strictly, because they say because this particular aspect, factual aspect, that it's a government land. So state government will be the beneficiary. Maybe you are entitled for that amount.
No, my lord, I am claiming on the land also.
Land also, on the land, the amount deposited towards the land as compensation, you are claiming. But should you adopt this procedure, then I think perhaps you are barking up the wrong tree. Because this will always end to this question: who was the recorded tenant? You are on a course of litigation where recording in the revenue record of right becomes very crucial, or the what you call that linchpin of the entire case.
But in normal action cases, my lord, even if there is a record of rights in someone's name, but if the title is clear, then compensation has to be in apportionment case.
No. You show me a single precedent on this.
My lord.
Apportionment of a subsequent person in interest.
My lord.
He could be a legal heir. He could be a subsequent purchaser. He could be a co-parsoner. He could be a co-sharer. He could be a sharecropper. That is another thing. Apportionment is between these persons. But look at the statute.
What I'm saying is that the wrong recording of name does not create a right title interest on a certain person.
But you look at the statute. It is. Person interested is defined.
My lord,
that is section 3B, my lord.
It's also define the person interested.
Where? It's a copy you have, so I'll have this.
Yes, madam.
You don't require now?
No, I have.
Okay.
2D, my lord.
It is almost similar.
My lord, exactly the same. What has been referred in section 3B, this is the exact language in section 2D.
Now, please find out that section where it says that how it is to be dealt with.
My lord, the compensation, that is section 14, my lord.
Sorry?
Section 14.
1.4.
1.4, my lord.
Please.
The method of determining compensation.
No, where it is to be deposited.
I get.
Section, yes, Mr. Mahanti? You said something.
That is 14 is the power of the tribunal to apportionment or determine the compensation, not right.
Not the right title. 14 subsection 5 is the relevant portion.
Compensation is sections.
And 6.
17, payment of compensation. Section 16 is the award and payment of compensation.
Mr. Das, kindly read 17. Any compensation payable?
Any compensation payable under this act may be tendered or paid to the person interested entitled thereto, and the central government shall pay it to them unless prevented by someone or more of the contingencies mentioned in subsection 2. If the person interested entitled thereto shall not consent to receive it, or if there be any dispute as to the sufficiency of the amount of compensation to receive it or the apportionment thereof, the central government shall deposit the amount of compensation with the tribunal, provided that any person admitted to be interested may receive such payment under protest as to the sufficiency of the amount. Provided further that every person who claims to be an interested person, whether such person has been admitted to be interested or not, including the person referred to in the preceding proviso, shall be entitled to prefer a claim for compensation before the tribunal. Provided also that no person who has received the amount otherwise than entitled to prefer any such claim before the tribunal. When the amount of compensation is not paid or deposited as required by this section, the central government shall be liable to pay interest.
3 is not relevant, but kindly just look at 2.
My lord.
2, that or if the person interested is entitled thereto shall not consent to receive it.
My lord.
Or if there be any dispute as to the title to receive it.
My lord.
So you are squarely covered there.
My lord, what I am submitting, my lord, title here does not refer to only the ROR, my lord.
No, that whether you are entitled or ultimately, that's not the point.
Lord.
The point is you have to go to the tribunal.
My lord. My lord.
Because it says then the second provision.
My lord. Provided further that every person who claims to be an interested person, including the person referred to in the preceding proviso, shall be entitled to prefer a claim for compensation before the tribunal.
No, bracket is important for you.
My lord, whether such person has been admitted to be interested or not.
So that's the problem.
My lord.
There is a dispute as to the title to receive it. Second, that the project proponent here, coal bearing, the coal company, whoever, MCL, they do not admit that you are entitled.
No.
And the basis of their doubt or their raising a record of it.
They are not disputing exactly. They are saying that this tribunal cannot go to the question of title.
Correct.
This is the proposition.
No, unless you see the genesis is that they are dispute. If they consider that you pay to X, then why the tribunal will not be bothered? I don't think the tribunal has any scope also.
No, my lord, what I humbly say, my lord, I have found some judgments in this regard where the tribunal can go up to the extent of right title interest.
No, on coal bearing areas act.
Yes, my lord. On coal bearing areas act only.
Please show
my
that.
lord, may kindly see
that.
the act section 26 first. Kindly for a moment.
Yes.
Section 26 says. Section 26 is jurisdiction of the civil courts. Save as otherwise expressly provided in this act, no civil courts have jurisdiction in respect of any matter which the central government or the competent authority or any other person
so that is empowered. You. That is against you.
No, my lord, I have approached the civil court.
26 is a bar as far as the determination under this act is concerned.
After notification.
True, my lord. That is true, my lord. After the acquisition.
So that 26 doesn't help you.
My lord, when the question arises for acquisition, I have approached the civil court. There, the MCL authority, the requisition the written statement. They said
for civil. So if I have understood, your submission is that since 26 is a bar, I have to approach the tribunal.
True, my lord.
So for 26 to be a bar, the 26 is very specific actually. 26 is partly, it cuts both ways as far as your case is concerned. Kindly read it slowly.
Lordship, only one point I have, para 8, your lordship see that.
Para 8 of?
Para 8 of the judgment. That is,
Tribunal judgment.
tribunal judgment. He has admitted that the land is recorded in the name of government. That is PW1.
No, in fact, Mr. Das, to be fair, he has not disputed. He's not disputing. He's not disputing.
My lord, my only question.
He is trying to make out a case out of the existing facts and circumstances.
Exactly, my lord.
He's not disputing.
Here is a case that.
So that is the reason. That is the reason I'm telling him that 26 is not in his favor. It could be against.
At the time of acquisition, there is a government land and premium has been deposited before the government.
It has to be. It has to be.
That is the case.
If it is a acquisition by the government under the 1894 Act or the latter Act, no compensation is payable.
My lord.
No compensation is payable.
My lord.
Because you see, there are instances where the compensation against government land has been paid.
My lord, I am referring to a judgment of Honorable Jharkhand High Court because there the Coal Bearing Act is also prevailing, my lord. And
Yes.
Lordship, kindly see paragraph 17 onwards.
Paragraph 7.
17, my lord.
17,
my lord. May I read, my lord?
Yes.
So far as the contention of Mr.
No, kindly look at 12 first. Actually, because straight away losing. Look at 12. Otherwise, you lose track actually.
My lord.
Or you can straight away start with first 5. Para 5.
Paragraph 5, my lord.
Yes.
Yes, my lord.
On the basis of rival pleadings.
On the basis of rival pleadings of the parties, learned trial court framed the following 9 issues.
Yes.
Is the suit is framed maintainable?
So look at from those issues whether there is a dispute regarding ownership between government and the ROR recorded because it's a government khata.
My lord, my lord.
Government khata basically is much better than even a sale deed or a deed because government land as far as record of right is concerned. Because the normal concept is what? The revenue record of right neither confers nor extinguishes
my lord, neither creates nor extinguishes, my lord. That is
any right attributable to any party.
My lord.
But when government land is there, then what is the basis?
Lord, the basis only basis
for government land, the record of right is the only document which confers the title.
My lord, the same government has conferred title on me. Why I am saying that I am claiming on title? Because the same government in 1980 has settled the land, the particular land, in my father's name. And I have
also disputed.
My lord, I am submitting. I am not going away, my lord. The same document through Exhibit 5, I have annexed before the learned court below, my lord. Before the tribunal.
No, Mr. Das, for that reason, I have been repeatedly telling you,
my lord,
that the process you are adopting to establish your right over this compensation has led to this situation where you are not getting anything.
No, but now the state
because suppose you establish by filing a particular suit, suppose a civil court is saying that 26 is a bar, I will not adjudicate. You can challenge that order.
My lord.
You might have got a hint what fell from the discussion.
Lord, exactly the
what you are saying, what you are now trying to establish, that on the notification, on the date of notification of this particular land acquisition, government, it is a government land.
True, my lord.
And for government land, you don't require any valid deed of conveyance. Once a government land, always a government land. You must appreciate that. You don't have to show that whether there is a deed of conveyance or anything or that kind of a thing. It could be converse. Like the petitioner is claiming here that I was a settlee. I was a settlee under OPLE Act or a OGLS Act or any other government grants act. I was settled with this. I am a grantee.
My lord.
So that on the date when this acquisition was set into motion, your own case is that I am not the owner.
My lord, I am claiming title only on the basis of the settlement.
But the problem for you, did you get the ROR corrected by filing an appropriate petition?
That is true, my lord. But then the law
That's
comes,
the difficulty.
the settled law comes.
So the problem is that 26 is not a bar what is to be determined under this act. But for everything else also. For everything else, then you have to go to the other court.
Lord, the question of the jurisdiction of the civil court comes from the date of and after.
That is hypothetical. Then just read again that particular line. Kindly read in respect of any matter.
Lord.
Mark that. That is only out of the much bigger jurisdiction of a civil court, only that portion is carved out.
My lord.
Everything else remains with the civil court. Everything else remains with the civil court. And unfortunately, on the date, neither there was any petition filed by you. Suppose you would have shown on the date of acquisition. Achha, what was the date of publication of the record of right, which you are claiming was wrongly published?
My lord, in the 1980s, in the year 1980, the land was settled in my father's name.
So usually in Odisha, you will find many settlements in 82, 83.
Right, my lord.
There is a purpose in my question. That in 82, 83, if it was not recorded,
my lord,
that was the cause of action for you.
My lord.
This acquisition is dated
2013, my lord.
2013.
My lord.
So it is almost 30 years or more than.
My lord.
So that is the difficulty, because you are actually you are the beneficiary, you should get it. But since you waited for this much and you initiated everything post acquisition,
my lord.
And please mark again 26.
My lord. That is the
no civil court shall have jurisdiction, that is clear, in respect of any matter which the central government or the competent authority or any other person is empowered by under this act to determine.
My lord.
As far as validity of record of right, central government or any other authorized person is not entitled, not authorized.
My lord.
Regarding right title interest, they are also not authorized. Only determination on compensation.
Lord, that is exactly
so that is how you say that yes, that is a record of right. Are you disputing the record of right?
No, my lord. I'm saying that
That is the
record of
problem.
right cannot be a basis for saying that the state government is the rightful owner.
Then you show me a decision that
I'll do
for
that.
state government land, you will never find. Record of right cannot be a sole basis for attributing something, a ownership to a private person.
My lord.
But you are carrying coal to the new castle.
My lord.
You
My
look
lord,
at
at least-
record of right, column 1. What is that? Have you marked record of right? There are 10 columns.
My lord.
What is column 1?
Lord,
Don't think that you are caught unaware. Please, it's not nothing something that way. A record of right is published by the government itself to be the owner. Odisha Sarkar, Khewat number so and so, so and so. Column 2, Prajara Nama.
Prajara.
So that column 2 entry or the Mantavya last column entry does not confer any right title interest. But one never gets obliterated. Prior to independence during the princely estates, that there is a possibility that it would be some other so and so, Sri Sri Amko some king. The problem is you are thinking that record of right is a right interest on the government. No. Government issues the record of right as owner of every land to a particular person. Who is paying rent? Who is paying rent? It may be Khajana, Jalakara, says everything. There can be several status. It can be Stitivan, it can be Chandana. There are so many things. Those are the other columns. Your problem is that you are challenging column 1.
My lord.
So for government owning a land, that is how it is. Then how you are saying that government is exercising eminent domain for exacting compulsory exaction of any land of any person?
My lord.
Because it is also presumed that the state holds the entire land as parents patria, like minerals or everything. Between this particular person and the other, litigants, now in this particular, they may have a dispute. Somebody may say that since in my name it is a record of right, I should get it. He's not part of the family tree, so he's out. But your challenge is to the ownership of the land on the basis which is recorded in the name of the government.
My lord. Lord, the second.
And if the publication is of 82, the cause of action arose in 82.
My lord.
You don't challenge it. You wait till 2013. 2013, the whole process sets in. This acquisition and this is acquired, everything is done. Then you challenge. And 26 is only a bar for determined by central government or the tribunal or the person authorized. Only those 3 things are to be barred. Everything else is open, still open.
My respect.
Now just imagine 2011, this person has particularly instituted a suit against the government that is still pending for declaration of right title interest. That is decided in 2025 by the High Court. What would happen? 26 will be a bar. 26 will not be a bar. Second thing, after the right title interest of the person is declared, or say declared, so he is to get the compensation, because now the person is a residuary claim. He will have to simply say that such and such land where the litigation was pending, it was deposited with the Tahsildar or wherever it was deposited. Now I have this, the right title interest has been established by the proper court, confirmed by the High Court or the Supreme Court, and I am entitled for disbursement of this thing. But you are in the reverse motion. After everything is done, you start a claim.
No, for me,
the same thing will happen. Suppose you would have initiated this 52 survey settlement proceeding for correction of the ROR before 2013. It is decided today. The consequences will follow.
Oh, my lord.
And if you apply the same logic, then can they challenge that order where this right title interest or the record of right is corrected today in 2025? They cannot. Same thing applies to them also.
But Lord, may kindly visualize this.
So kindly look at Justice Chaudhary's judgment.
My lord.
Yes. Just
paragraph
find out. Paragraph 5, there is no reference to any record of right being recorded in the name of the government. It would be a precedence on which it decides.
Lord, this particular judgment says that the tribunal can go up to the question of title.
No.
That is my submission, my lord.
No, the context you must realize. Please don't miss the context. That cannot be the ratio of this decision. If you don't refer to paragraph 5 and 9, then kindly look at para 9. Do you find anything in para 5?
Para 5, my lord, issue number 7.
Yes.
Issue number 7, my lord. Have the plaintiff subsisting right title and interest over the land.
Just look at where the litigation started. Who were the plaintiffs and who were the kindly mark para 3.
My lord.
There is no question of any government land involved.
My lord, admittedly, there was a dispute between the parties in this case. Question of title was the question.
In fact, I was giving you that example. Suppose there is existing suit between any person, the litigant here and the government earlier pending. The coal bearing areas authority has to abide by their decision. The tribunal has to give a determination that yes, in the pending case, he is to benefit. There is no pending case here.
My lord. There is
though government, it is a government land, it is a recorded government land. My father was allotted in 1982. They dispute that. That's another problem for you. So I should be given. But from 82 to 2013, you remain idle.
Lord, for the appellant.
So here, what is the difference? Just look at the first line. Fast track court Chhatra in title appeal number 19 of 2000. Appellate court dismissed the appeal and confirmed the judgment. Decree title suit 7 of 1996. These two things are not there with you. In a pending dispute, appellate suit number 7 of 96, then 19 of 2000. Thereafter it comes, then I think the acquisition process has started. Yes. So that is how you don't find, unless a particular issue is framed and it is answered.
The issue before the court was whether after the acquisition, the civil court has any jurisdiction to go to the question of title.
That is what I am telling you. That at best your submission is that the tribunal dismissed my appeal, my claim on a wrong premises. But that is, suppose you did not agitate your right before a properly constituted suit like this, in this particular judgment. Title suit filed in Chhatra, then the first appeal, you have nothing. So how can the tribunal decide it?
My lord, I have initially
the High Court says, this particular judgment says that
since the suit was filed, then the first appeal was filed, then the second appeal was filed. Thereafter, the acquisition proceeding, the tribunal should go into those details.
My lord,
Here, you have nothing.
I have filed one civil suit.
When did you file that?
I have filed in 2013.
After the acquisition.
1 minute.
After the notification.
In 2013.
No,
No.
not significant, Mr.
My lord,
Das.
for me, my lord, the cause of action arises when the land was acquired.
No,
Because
no,
there was
no. They win hands up, hands down. So
Lord,
don't say that. I mean, don't jettison any of your plea now.
True, my lord.
It is too premature because you do not know what will happen.
Since 1980s, my lord, on the date of settlement, in the name of my father.
No, so that settlement.
My lord, that is Exhibit 5. That is exactly I'm saying, my lord.
Settlement not by order, settlement record.
Settlement case was there.
No.
This, my lord, Lordship, may kindly see order number 21.
The problem for a civil court or for a writ court is that I cannot go behind those records.
There's a record
The
before
problem is
learned-
the record of right. You see the date of publication of record of right. I cannot go behind that.
Lordship, may kindly see order number 21 of this honorable court. Order number 20.
But let us not change the track.
No, my lord, that was exactly.
Let us be. You see that your submission has been noted by order number 21. That's fine. No problem. But can this court now go beyond the record of right to say
No, my
that?
lord, I'm not saying that.
So please look at record of right. Why you are avoiding or evading that?
No.
Look at the record of right if they are referred.
I think that is in the LCR, my lord. Because
Yes.
my lord, I cannot say about the
Very
R1.
slowly read that.
My lord, I cannot.
I cannot say about the ROR.
My lord.
You are in a self-denial mode.
My lord.
You could have relied on the ROR with a mantabya, jabar dakhal, or behind dakhal, or because that shows the indication that you are in possession. But you are simply saying that I do not know about the ROR. Then read further. I cannot say about the ROR. Then read further.
It is not a fact that the land was a government land and given to MCL. I have filed ROR in the name of my father as to the. I have not filed rent receipt as to the suit land in this case. I do not know about any notification under section 479 of Coal Bearing Act. I do not know about the acquisition and award. I have not filed any complaint before anyone for correction of name of tenant in the ROR as to the case land. I do not know the contents of my affidavit.
Oh, that be a mistake.
My lord.
I do not know the contents of my affidavit. He is a layman. He cannot write.
I do not know about.
So how it will do? You have denied your affidavit?
But with the experience, the limited experience, my lord, I can say that in many of the cases, my lord, the layman says like this, my lord.
No,
and the court has a duty to look into the documents, my lord.
It is not in English. It is a translation. It is a translation. It could not have missed if you deny your affidavit, examination in chief, your lawyer, the judge, they will not. Then kindly read further. I do not know the contents of my affidavit.
My lord.
I do not know about any land.
About any land settlement proceeding before Tahsildar. I had applied in the settlement camp for recording of my name as tenant. I do not know what happened to it. It is a fact that I was not taking care of my land as my father was taking care of it. I cannot say the khatan of the case land. I have not applied to MCL to get the award money. Nobody else going to depose from our side in this case. Paragraph 16, my lord.
Well, leave it there.
My lord.
There. So how do you establish it now? Even suppose look at the next page, page 19. Scroll down. Exhibit 5 says certified copy of order sheet.
My lord.
That you are referring to.
Yes, my lord. Exhibit 5.
But in your statement, you have.
No, that was a mistake, my lord. That was there. That was not there. The certified word was never there.
No, it may not be a mistake. Exhibits, whether they have been scanned or not, I do not know.
That is there, my lord. That is there on the record.
It is not a certified copy. You are looking at this.
My lord, exhibit 5.
Scan copy. Exhibit 5 is there.
Scan copy, my lord. I have the.
It doesn't bear any signature, seal, anything, nothing.
That is exhibit 5.
Just scroll down a little bit below. It comes after that order sheet. After the order dated 10/12/2014.
That will be the plaint, my lord, of CS 2630.
No.
After the order sheet.
Potta lekha hai upare. Can you read Odia?
My lord.
Potta, Jilla ढेंकानाल, Tahsil Talcher, Moja Hiloi, Thana Colliery ko Colliery lekha hai.
My lord.
That is a CA 152 of 200 something lekha hai.
Lord, I think that is
exhibit dated 29/3/14.
My lord. That is there, my lord. That is a single page document.
Single page document or nothing?
That is not exhibit 5, my lord.
That is exhibit 5.
No, lord, that is.
If you can just enlarge it, I am looking at 100%. Enlarge it and mark the top right.
Lord, so what I can see, my lord, that is a document just below 2 pages down, my lord. There is a reference 8 in that document.
Below that, it is their application form for issue of resident certificate.
My lord.
Above that.
Yes, my lord. Potta. The document in the right 29.
क्यों उद्देश्य रे दिया गला 400
My lord. It is a CA number mentioned.
CA is the reference of the case number where it has been marked, and exhibit is marked EXT, and then there is a signature dated 29/3/14.
Lord, what I can see, Lord, just before that application,
Yes.
just
Yes.
below that, there is a reference of A. That is Exhibit 5 as per my record, my Lord. There is a reference
Exactly.
of,
So that doesn't bear any signature certificate or any countersign.
my Lord, that is there, my Lord, in the record
Certified
itself.
copy.
Certified copy.
It's not certified copy.
Lord, Lordship, may kindly see that is.
Certified copy of the court you are saying.
No, my Lord. Certified copy originally,
It
which
is
the
not there.
petitioner
It is
has
not there.
obtained. That is there.
If you have a
Lord,
copy, can you show me? I can
Lord,
verify. Ganeshwara Behra.
my Lord.
He is the father.
Father of petitioner, appellant, my Lord. In page number 38, that has been mentioned particularly, my Lord. As such, my Lord, the line starts, my Lord, in page 38 of that exhibit. That is also in the scan record, my Lord, scan copy.
Yes. What is your response to this you are saying? Kindly speak to the microphone. Kindly speak to the microphone.
The state with one instruction, my lord, that is a flag K, my lord. That may kindly be
That is pursuant to the direction that Mr. Das was referring.
my lord. Flag F. It is there in flag F, my lord. So the Tahsildar says that
Just a second, I'm getting it. Flag, you are saying flag F. Yes.
my lord, that instruction, my lord, the order sheet, my lord, is that, my lord, annexure A by 7 of that. That may be seen, my lord. The land was settled in favor of one Balakrishna Ratha, my lord. Encroachment case number 1 of 1980.
Yes. 1 of 1980, 1 of 1980 in Odia.
Encroachment case so and so was traced out, and upon verification, it is revealed that subject plot number 6/3, area 0.63 decimal, Isam Talia of village so and so has been settled in favor of one Balakrishna Ratha. That it is also mentioned order sheet that correction of error was not done as the settlement operation was in progress. The form came and so that is annexure A.
You are Mr. Das. Just a minute. You are referring to the order dated?
Order 21, my Lord. Order 21.
No.
Order number 21.
Not order number 21. I'm referring to the order by which you have settled the land. Your father has settled. Dated?
That is 80. Lord, I'm just referring to the. Lord, 6/12/80.
6/12/80.
My Lord.
It doesn't match.
My Lord. My Lord, may only.
I thought that it is not traceable.
It is not.
Initially, I was thinking
But the case number and the order sheet, everything they have produced.
No, it is not traceable only, my lord. They have said in their affidavit.
No.
The originals are not traceable, they are saying.
So what they have filed?
They have filed the duplicates only, my lord, not the originals.
Not duplicates, these are photocopies. These are not duplicates.
Photocopies, my lord. They have said that the originals are not traceable due to some are damaged.
So even suppose, let us assuming that you had the order. So there are two competing orders, Balakrishna and so then how can now this still worse?
My lord, on that situation only, this honorable court in order number 21 has specifically directed them to take instruction which one is the correct one. My lord, if at all this document goes, my lord, if it is found that the certified copy is not true, then my case goes, my lord.
We are common law system. The judges are not to inquire, hard hitting conduct, hard hitting inquiry.
My lord.
See, in civil law system, we act as umpire. Balakrishna, government, MCL and this Mr. Behra, Ganeshwara Behra. For you find it out whether Ganeshwar is better or Balakrishna is better. That's not my job.
Because there is a certified copy of it, which was exhibited.
No, certified copy actually in the statement it is not mentioned. And the copy doesn't appear to be a certified copy.
Lord, I have given that document where it is
No,
certified.
original, you see, this looks like the certified copy of the court where it was.
My lord.
Suppose you file a exhibit.
My lord.
Now again you obtain a certified copy from that court.
This is not the case where the
court
copy has been given.
This color, this black and white doesn't show anything. So I am not sure.
This is the photocopy which I am having, my lord.
So
but in the court,
this doesn't show that this certified copy was by the Tahsildar. That is the problem.
my lord, that there is a signature, my lord. 3 signatures are there just below the page.
And the worst part is that they produce a copy where Balakrishna Behra, the same order, same case, different order.
My lord.
So how can the court will now decide? High Court will say that this is not Balakrishna Behra.
That is why
I'm sorry, Balakrishna. Ganeshwara Behra, Balakrishna
Ratha. My lord. That is why.
So whether it is Behra or Ratha, how the court will decide now?
That is why, my lord, the order
because the endeavor by this court to get something has landed up to led to more of this confusion.
Lord, there was a specific order on this regard, my lord.
No, I will not go by that. I cannot state to say that whether this is right or that is right because that is a risk taken by the court.
Lord,
I am not the investigating agency.
No, Lord, I am not saying that.
Mr. Das, your client has to fortify his case. Court doesn't have any interest to find out whether Balakrishna Ratha or the Ganeshwara Behra are the beneficiaries.
No,
the other problem is that in the present case, Balakrishna Ratha is nowhere in the picture.
No, Lord.
What has happened to him and what has happened to his land, nobody knows. Then what is the interest? What is how the court will make out a fifth or sixth case, not even the third case. Usually the courts are appeal said that the London court made out a third case on its own. Here it will be a fifth or sixth case.
Lord, at least let them say that my certified copy document is false one.
No. Certified copy is not the certified copy. That is their consistent stand. They are not supposed to say they objected it. The court did not believe it. The other problem is that now when the court asks them, the appellate court asks them that you produce the order, they produce a different order, saying that this is the order we are having.
And after that,
and interestingly, you have not produced anything. Suppose you would have produced in your statement, you have not said it is a certified copy. This doesn't look like a certified copy issued by that particular. It can be a copy of that certified copy. I do not know. Because this color cannot, I cannot, it doesn't look like an original stamp, so I cannot say. Or it could be a stamp and then photocopied. Both ways possible.
My lord.
So if you have produced the certified copy before the which court?
My lord, before the tribunal in Talcher, my lord. I have produced it.
So original records dekhele? Mrs. Mahanti, this passed over your matter will take time, so let it be date be fixed.
Rest of the matters your lordship will take up tomorrow.
Rest of the matters will be listed tomorrow. The list further matters will not be added. Say the scan copy, original magaya pure. This is the same thing, Mr. Das.
They have taken printout of this paperless. Since the learned counsel for the petitioner appearance लिख ले लिख दीजिए appearance डका है नहीं Mr. I'm sorry, you are Mr.
P. Das, Praveen Das.
Mr. Praveen Das, P. Das, P. Das for the appellant. Mr. Vedprakash Ponda.
Yes.
For the
8 and 9, madam.
respondent 8 and 9. You know, लिखी थी आपण माने नथिले बोलते. हां. Eight and 9, Mr. I'm sorry, your name, please.
R. Pradhan.
Mr. R. Pradhan, Additional Standing Counsel for the respondents
5 and 6.
6 and 7.
6 and 7.
The learned counsel for the petitioner was had at length. Learned counsel for the appellants was had at length. He submits that the appellant had filed certified copy of the order dated 6/12/1980. By which the land was settled in his favor, settled in favor of the predecessor in interest, Sri Ganeshwara Behera. The learned counsel for the state refers to the affidavit dated kete कहले authority
Affidavit dated 16/1/25.
flag
Flag A.
That is annexure A/7.
affidavit dated 16/1/25 filed on behalf of the respondent number 6 and 7 pursuant to order dated 13/2/24. Which disclose following. Paragraph 4, 5, 6. Mr. Das, read paragraph 6.
Hello.
5 and 6.
That it is pertinent to mention here with that.
Just a subpara before that.
Well, hence
the encroachment case number 1 of 19 is at annexure A/7 to the affidavit. Read that slowly.
Hence the scanned copy of the encroachment case.
No. Para 5 subpara, sorry.
Para 5, my lord.
Para 5 subpara.
Para 5, my lord, there is no subpara.
You are reading which affidavit?
My lord, the affidavit filed by my lord respondent.
Dated?
My lord, that is 28/24.
No, 16/1/25.
16/1/25, there is no supply. My lord, they have never supplied it. Only
My lord, that is not 16/1/25, my lord. My lord, just me.
that is, I think, 28/20.
28, 20th August of 2000.
That they have supplied first, my lord.
Naimo? It is there, sir. It is there.
My lord, that is the affidavit, my lord, 20. Received by the applicants, they have also received.
16/1/25. I am correct.
My lord, affidavit dated 28/24, my lord.
No, that is 16/1/25 is much after that.
The affidavit, those are instruction on it.
Order dated 13/2/24. Flag I, that is flag I. So you find out and you serve a copy if you are not having it.
No.
He says that
No, my lord, copy solved the 28-24 I have
16/1/25 or it is there.
16-1/25.
Paperless, you can see that there in the brief.
I'm trying to.
Yes. Flag. Look at flag I. Click flag I in the bookmark.
16-1/25.
Flag H, flag I.
So we'll call it. It will be. We'll continue with this tomorrow because there is no time. I have some other assignment actually. I can't continue.
If I try to get the certified copy, if it is possible, my lord.
No, they have said already. That has been answered here.
My lord, that they have not supplied. Let them supply that to me.
So let us complete this procedure, at least today's proceeding.
My lord.
Because they are very clear. They are very clear. You are thinking that this is a certified copy. Actually, they have verified the records are available. They have provided the records. This particular exhibit 5 is not available.
My lord.
Perhaps you are thinking that this is not the original. They say that this is the original, and you found out paragraph 5.
Lord, that is
flag I. So item 19 tomorrow. This matter tomorrow. Leftover hela. Rest of the matter semti rahila karte leftover. Je adjournment magibe de debe. Adjournment both side rahithwa darkar. Adjourn guda let me dictate. Item 20 ko jaye chene apno?
23.
The button 23. Item 19 tomorrow. Because passed over. Then item 24. 24 who is appearing for the state? Kindly, may I have your attention? State. 24 ki appear korchon?
My lord.
Mr. P.P. Behra. K.K. Sethi for the petitioner. Mr. Prabhu Prasanna Behra for the opposite party. 12/5/2025.
My lord.
Adjournment is sought for of the learned on behalf of the petitioner as spread for list on 12/5/25. Then item 29.
My lord, 26-27, my lord, I am appearing for the petitioner's lordship.
Mr. Behra, the matters which are not raised, I will not be able to take up. It will be called tomorrow.
Lord, 26 and 27, in which your lordship has just passed orders, my lord.
I have not passed any order in 26-27. No. I have not passed. I have passed orders up to 23, which is listed for tomorrow. The order will be dictated. Then I have taken up 24, going serially. He has not called even. Only I am taking up those mentioned matters. The list has stopped at 4:15. No time. Then item 29. Miss Sonali Parida for OP 1 and 4. Anyone for petitioner? 29 petitioner, none. Sonali Parida, OP 1 and 4. List after 1 week as prayed for by the learned counsel for the opposite party. Then 31. Anyone appearing in 31?
Your lordship, item number 30.
Tomorrow.
Your lordship, 1 week after we will be filing out on behalf of the opposite party.
Wherever you want a date, you give it to the court master. I am not taking up any matter. He will just give you a date. Or it will be called tomorrow, the order will be list kar diyantu. So say they will not be confused also. 31. S. Sahoo for the petitioner. Anyone? Mr. Bhanjadeo? Opposite party blank. List after 2 weeks as prayed for. Upon date the party. Jota jai debe 31. 13/5. 32. Mr. Anjan Kumar Biswal for the petitioner. Who is for the state? 32.
Mr. Sethi, AC. AC for the state. 7-5 है. 7-5 by petitioner.
33.
Mr. A.S. Patra on behalf of B.B. Mishra for the petitioner. Opposite party blank. Anyone there in 33? Opposite party blank. List on 2525 as paid for by the petitioner.
35.
Mr. S.K. Divedi for the petitioner. Anyone in 35? Opposite party blank. Are other side going to appearance likhi bani. Ita kar. को मैटर अपन दोचंती कौन दोचंती 35 रे की अपेयर करचंती थे नहीं तो दयानिधि साहू प्रमोदिनी साहू कौन दयानिधि साहू प्रमोदिनी साहू who are they कल्याण absence रे कॉलेज से प्रॉब्लम हो कि फिर क्वेश्चन जाना ना एटा टुमारो ना टू बी मेंशन कर दे इफ टू बी मेंशन ऊपर नहीं आया 38 completed ना dictated already कि नहीं चलते जाना then 40 Mr. Satyavadi Mantri for the appellant 40 who is the for the respondent state
My lord, Rajdeep Pradhan.
Mr. Rajdeep Pradhan AC London Council for the appellant 6 accommodation due to personal difficulty आज prayed for list on 24/6/2025 so rest will be called tomorrow including the mentioned matter where someone has filed some wakalatnama item 35
My lord, item
Thank you.
27, can I please pray for after vacations?
Definitely.